Almighty God, we give thanks to you, the creator of the universe, the most merciful, the most beneficent, and humbly beseech you to direct and prosper the deliberations of the members of this house here, assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established amongst us for all generations.
Auto affirmation, announcements by the Speaker.
Honourable members, I have received communication from Mr. Carl Mimbert, Member of Parliament for Diego Martin North East, and Mr. Joel Sampson, Member of Parliament for Tobago West, who have both requested leave of absence from today's sitting of the House. The leave which the members seek is hereby granted. Is he here? Leader of the House.
Thank you kindly, Mr. Speaker. Mr. Speaker, I have the honor to lay the consolidated audited financial statements of the telecommunications services of Trinidad and Tobago for the year ended March 31st, 2025. Mr. Speaker, I beg to move that paper 1 be referred to the Public Accounts Enterprises Committee.
The question is that paper 1 be referred to the Public Accounts Enterprises Committee. All in favor, say aye. Aye. The ayes have it. Leader of the House.
Thank you, Mr. Speaker. Mr. Speaker, I have the honor to lay on the table the following papers as listed on the supplemental order paper in the name of the Minister of Public Administration and Artificial Intelligence. 2, the annual report of the National Information and Communication Technology Company Limited, IGOV-TT, for the fiscal year 2022 to 2023. 3, the annual report of the Telecommunications Authority of Trinidad and Tobago, TAT, for the fiscal year 2022 to 2023. Thank you, Mr. Speaker.
Announcements by the Speaker.
Members, as you are aware, and having regard to the inquiry made on the last occasion by the member of Lopino, Aruka Lopino, as you all members were aware, there were 3 complaints of privilege advanced some time ago. I do not want to elevate them from motions on privilege, but I will describe them as complaints in writing. I propose now, I've considered them, and I propose to make a pronouncement on them. Each one I will deal with separately. By way of introduction, this is a ruling on 3 complaints regarding alleged breaches of privileges of Parliament. The complaints were submitted by the honourable members Lopino Lopino, I beg your forgiveness, Diego Martin Northeast and Couva South. The first 2 complaints relate to 2 alleged instances of unparliamentary language, which further alleges that such language constitutes a breach of the privileges of Parliament and warrants the invocation of the penal jurisdiction of the Parliament. The complaint made by the honourable member for Couva South alleges a course of harassment and other behaviour which, according to the complaint, also constitutes a breach of privilege. They each independently seek my leave to have their matters referred to the Committee of Privileges. And this, whilst there is a practice that has developed in the UK where complaints of this nature are made, sometimes private correspondence is sent. Because of the fact that I had intended to do that, but because of the fact that the complaints were widely disseminated on social media, I think it's in the public interest that I justify my decision, elucidate my reasons for my decisions. What I propose to do is start with the complaint for the member for Couva South, and I think that very little needs to be said of this complaint. I think, in my respectful view, it is entirely devoid of merit altogether and does not meet the requirements of Standing Order 32, and as such, there is no need for a lengthy disposition of this complaint. I move now, in order to give my reasons with regard to the complaints for Diego Martin Northeast and Aruka Lopino. I propose to give my reasons for Diego Martin Northeast's complaint first. And what I propose to do is deal with it under several subheadings. The regulatory framework, the jurisdiction of the House to deal with matters of privilege is set out exclusively under Standing Order 32. Whilst Standing Order 32 provides a jurisdictional basis for the House to make inquiries into alleged breaches of privilege, it stops short of identifying several key and vital factors which must be considered in any potentially penal proceedings. It is to be noted that Standing Order 32 makes no provision for the following: A, what actually constitutes an infraction of privilege; B, the constituent requirements of a breach of privilege complaint; C, the constituent requirement of which must be requirements of particulars which must be contained in a privilege complaint; and D, the evidence which is required to be cited in support of the complaint. Now, whilst that may not be so in Standing Order 32, I have found in a ruling by the Honourable Barendra Sinanan, Speaker of the House, delivered on November 28, 2008, in which the Honourable Speaker elucidated the requirements of privileges complaints. And this is what the then Speaker said. Honourable members, the first ground raised by the member for Diego Martin West is in the realm of contempt and can be committed by anyone taking. And it goes on, but the material part is, there are 3 elements to be established when it is alleged that a member is in contempt by reason of a statement that the member has made. The statement must have in fact been misleading. It must be established that the member making the statement knew or ought to have known at the time the statement was made that it was incorrect, and in making it, the member must have intended to mislead the House. Then the Honourable Speaker went on to deal with the burden and standard of proof in complaints of this nature. The standard of proof demanded is the civil standard of proof on the balance of probability. And I see Port of Spain North smiling, but in adherence to the Campbell principle, The Honourable Speaker then went on to say, but given the serious nature of the allegation, proof of a very high order, what is normally referred to by public lawyers as the sliding scale standard of proof in allegations of a serious nature. The need for such a high measure of proof is emphasized by the fact that there is effectively no right of appeal, even if a member was rash or negligent. In the use of words in debate, this, though reprehensible in itself, falls short of the standard required to hold a member responsible for deliberately misleading the House. So we can move on, having established that framework. The standing order only provides that the Speaker must determine whether a case for breach of privilege has been made out. That plainly sets in motion a threshold requirements, and the threshold requirements are what I referred to by Speaker Sinanan. Complaints must therefore meet a minimum threshold requirement. It is only when this threshold is met that a complaint is allowed to advance. Thus, complaints which do not meet the threshold requirement are, in essence, stillborn complaints. The Privileges Committee is not engaged except where the threshold requirements are met. Now, I want to put members on notice that in considering this matter, and that's why I gave it such deep consideration, there is a fundamental legal issue which arises, which does not fall for determination on this issue. But there seems to me, from the learning throughout the Commonwealth, that a sharp distinction is drawn between matters which are strictly breach of privilege and which may fall more akin to contempt. The contempt jurisdiction is far more problematic as we see it, because the standing orders don't provide a procedural framework for the prosecution of those offenses, of those infractions. But as I said, that does not need to be resolved for the present purposes. In the circumstances, it is important that the first question that must be decided is what constitutes a breach of privilege in the peculiar factual matrix of these allegations. It is important to consider the historical context of the privileged jurisdiction. The jurisdiction to inquire into a breach of privilege is an important safeguard where Parliament protects itself and members from the use of offending or inflammatory language, intimidation, harassment, oppressive conduct, amongst other matters. The categories of parliamentary privilege are well established and do not need to be traversed seriatim for the present purposes. Suffice it to say that parliamentarians are accorded certain privileges which would enable them to serve their constituents without being intimidated, harassed, or oppressed. In 1966-67, to give some context of how the penal jurisdiction of the Parliament is exercised, I make reference to a select committee in the UK Parliament which produced a report. And in that report, the select committee suggested two things: that the House should exercise its powers of privilege, A, as sparingly as possible, and B, only where it is satisfied that the exercise of the power was reasonable for the following purpose: in order to provide a member with reasonable protection from A, improper obstruction, or B, an attempt or threat of obstruction causing or likely to cause substantial interference with the performance of their respective functions. According to the learned editors of Erskine May Parliamentary Practice 25th edition at page 311, the rationale for the rule is quite clear. The procedure is designed to prevent frivolous complaints of breach of privilege. The gravamen of the complaint, I could lump them together here, of the two complaints by the Honourable Member for Aruka Lopini and Diego Martin Northeast essentially can be distilled into a complaint of disorderly, offensive words, or in more conventional terms, unparliamentary language. There is a commonality that runs through the complaints which raise the common issue of contempt of Parliament. it would be useful to set out the definition of contempt of Parliament as set out in Erskine May, Parliamentary Practice 25th edition at page 289. Generally speaking, any act or omission which obstructs or impedes either House of Parliament in the performance of its functions, or which obstructs or impedes any member or officer of such House in the discharge of their duty, or which has a tendency to directly or indirectly produce such result, may be treated as a contempt, even though there is no precedent of the offense. It is therefore impossible to list every act which might be considered to amount to a contempt, as parliamentary privilege is a living concept. Like the concept of fairness in administrative law, it is a protean concept. It is capable of taking on any form. The essential question to be determined in the case of the complaint of the Honourable Member for Diego Martin Northeast is whether the words complained of constituted an attempt to interfere with and to obstruct the member in the performance of his duties. Indeed, without getting into the particulars of it, if one were to examine the complaint made by the member, interspersed throughout this complaint is the two things. One, the apprehension of fear, and two, the intention to impede or obstruct him in the performance of his duties. Central to the determination of these matters would be the context in which the exchange took place and the intention to be derived from that context. In this regard, it would be important to note the nature and context of the exchange, and most importantly, whether a reasonable person could reasonably and realistically apprehend a realistic sense that actual violence was being threatened. The letter of complaint sets out a host of matters which seek to justify a reasonable apprehension of fear on the part of the member. The member also makes reference to the fact that the Honourable Prime Minister sits as the head of the National Security Council. This sub-allegation, as I refer to it, is nothing more than unhelpful hyperbole. The complaint seeks to pluck from the exchange one singular phrase and elevate it to the level of a real, clear, and present threat. It is not necessary to quote the actual exchange for the purposes of this ruling. It is plain, in my respectful view, that this is an attempt to place emphasis and weight on a singular phrase and to ignore the context of the wider exchange and the nature of the exchange that was taking place. The member in his complaint proffers the view, sorry, I beg your pardon, that he was of the view that it was not banter. As a general principle, the personal view of the member making the complaint is irrelevant and or immaterial to determining whether the words complained of reasonably engender the conclusion that it was uttered with an intention to molest, intimidate, harass, and also prevent the member from fulfilling his parliamentary duties. It is important to note that mere words in and of themselves do not ipso facto constitute a breach of privilege. There are additional evidential thresholds to be met. There must be a clear intention behind the words. Authority for this proposition is to be found in three sources. One, McGee, Parliamentary Practice in New Zealand, at page 773, in which the author, after examining a decision of the Speaker of the House of New Zealand, makes this pithy summation. The fact that the member took offense at the remark did not transform it into a contempt. I also want to make reference to the ruling of the Honourable Barendra Sinanan, Speaker of the House, delivered again on November 20, 2008, where the Honourable Speaker said this: "May I point out that reference to a member's private affairs is not automatically out of order. They are debarred only if they are strongly undesirable, insulting, or offensive." And this is the important aspect of it. In judging whether something is offensive, the chair will be guided to some extent by the reaction of the member to whom the remark is directed. If that member does not object, it will generally be allowed to pass. Personal references may be irrelevant, and we go on. But I want to also make reference to House of Commons procedure. And this is what the third edition, Canada's 150th anniversary by Mark Bowes and Andre Gagnon. And this is what the learned authors say. In dealing, can I have some silence, please? Barataria Sanwan. In dealing with unparliamentary language, the speaker takes into account the tone, manner, and intention of the member speaking, the person to whom the words at issue were directed, the degree of provocation, and most important, whether or not the remarks were created, whether the remarks created disorder in the chamber. Thus, language deemed unparliamentary one day may not necessarily be deemed unparliamentary on another day. So, cutting through that, running through it, you can see several principles emerging. I don't need to adumbrate specifically those principles because I think you understand them. Further to that, one must also consider the state of the House at the time the comment was made. Again, in assessing whether the words were offensive, a relevant factor is not only the circumstances and tone of the debate in question plays important roles in this determination. The reaction, as I pointed out, if the member does not object to it, as Speaker Symon said, it will be allowed to pass. And there's very good reason for that. When I get to Standing Order 55, members will see that Standing Order 55 is a self-regulating compendious code enacted by this Parliament to deal specifically with matters of crosstalk and insulting language. The procedure which is contained in Standing Order 55, and the punishment procedure, which is also self-contained in 55, and which, if I might add, is exercisable in a rather summary fashion, controlled by the members of the House themselves, really goes against the grain for saying that this is a matter which falls within the privileged jurisdiction. This is a matter which falls within the Standing Order 55 jurisdiction, and later on in these reasons, I adumbrate fully Standing Order 55. And I will explain why Standing Order 55 and the failure to invoke Standing Order 55 by the member makes this complaint a stillborn complaint. The comment was made in the context of a clear exchange of banter. The subjective thoughts of one of the member does not elevate it to a different level. I think that much is clear. The principles are clear. It is important to note that after the comment was made, the honorable member asked the honorable Prime Minister if she will meet him outside, to which she promptly replied, yes. Laughter then followed. There was no attempt to stand and raise a point of order pursuant to Standing Order 55 and raise an interjection then. This confluence of circumstances would lead to the inescapable conclusion that at the time the words were uttered, all members treated it as light-hearted banter, and there could not have been a real and reasonable perception of a threat of violence against the member. This was nothing more than banter. And further, there was no intention to intimidate, molest, harass, or prevent the member from performing his function. And B, it was not reasonable to apprehend the fear of personal violence. Now, Authority for this is further to be found in McGee, Parliamentary Practice in New Zealand at page 773, in which the author or the editor makes reference to a case in New Zealand in which he says, in another case, a jocular remark directed by one member to another in the division lobby was held not to be a contempt. The fact that the member took offense at the remark did not transform it into a contempt. From the above, and a consideration of the exchange, the only reasonable conclusion which can be drawn was that it was nothing more than banter. Further, no intention to threaten, molest, or intimidate the member from the performance of his duties accompanied the words. Whilst intemperate and inflammatory language ought to be kept in check, the complaint does not meet the threshold. It fails on issues which are material to the complaint and as identified by Speaker Symon in the 2008 ruling, and I rely on that. So the complaint by the member for Diego Martin Northeast is stillborn, and I so rule. We move now to the complaint by the member for Arouca Lopino. The complaint by the member for Arouca Lopino, in my respectful view on giving it studied consideration, raises some fundamental procedural and legal issues which thankfully do not have to be addressed for the purposes of this ruling. And I will simply identify one which I've sought advice on, and I've received two differing opinions. The Attorney General not being a member of this House, whether the privileges, and it's not up for discussion now, whether or not the Privileges Committee has jurisdiction over the Attorney General, which may seem to be straightforward, but it's a far more nuanced legal issue than that. But thankfully, we don't have to decide that. The first, and I want to put this neutrally, troubling aspect of this complaint is that it relates to video footage with simply a voice in the background, which sounds like that of the Honorable Attorney General. The letter of complaint references this voice as being heard. However, there is no actual video capture of the Attorney General uttering these words, none. No complaint was raised immediately when the words were uttered. Indeed, it is reasonable to assume that no one heard the words. I myself did not hear it. But the problem with that, thank you. The problem with that, which I will come to, is that there was a procedural misstep in bringing the complaint. No complaint was raised immediately when the words were uttered. It is reasonable to assume that no one heard the words. If those words were directed at someone in particular, it would be reasonable to assume that the member to whom it was directed would immediately raise a hue and a cry. At this juncture, I wish to draw reference to Standing Order 55, which provides the appropriate recourse to any member who suffers such a verbal assault. On a practical level, there are shades and gradations of disorder in the House. In this instance, the complaint falls under the rubric of the use of disorderly or unparliamentary expressions. And the learned editors of Erskine May at page 507 sets out what unparliamentary language is. I don't propose to deal with that. Standing Order 55, which concerns the conduct of the debate and breaches of order and decorum, adequately empowers the chair to maintain order and deal with any instance of disorder in the House in a summary, note the importance of that, in a summary, time-efficient, and expeditious manner. Standing order for completeness provides as follows. The Speaker or the Chairman, having called the attention of the House or committee to the conduct of a member, A, who has A, used objectionable, abusive, insulting, or offensive words or language or unparliamentary expressions, and on being called to order has refused to withdraw such words or language or expressions and not offered an apology for the use thereof. Or B, persists in irrelevant, tedious repetition either of his own arguments or of the arguments used by other members in debate, or engages in excessive crosstalk or converses noisily with another member or otherwise disturb the proceedings. And after having been warned, and I think you are all familiar with the summary disciplinary procedure which follows this. I think it is important to note that Standing Order 55, as I've said before, provides an important, comprehensive regulatory code for just, swift, and expeditious rulings on crosstalk, which is what is the nature of the complaint. I think we are all agreed that this procedure was not invoked. All we have, and then we go now to the nature and quality of the evidence adduced in support of the complaint. Or shall I say, the fact that no evidence was adduced in support of the complaint, and merely the reproduction of a clip on social media. It was only following a viral clip on social media that the member sought to advance a complaint. The complaint does not include any official broadcast as an attachment, nor does it include the official Hansard record. The complaint references a viral clip widely circulated on social media. It is important to note that no attempt was made to write to the Office of the Parliament to certify the recording. Rather, the words were taken from a viral social media clip. It is useful to know that the shared viral clip was also ambivalent as to whom the words were uttered towards. The official Hansard does not record those words. This begs the obvious question. Diego Martin West, please. This begs the obvious question. What is the record to be used? And further, what is the evidential obligation of a member making a complaint? A further corollary to this is that the member in his complaint has specifically made the allegation that the words were directed to an elected member of the House. In this regard, where such a specific complaint is made, there is an evidential threshold requirement. Whilst broadcasts form part of the standing orders, they do not give the broadcast the status of the official record. The official record remains that of Hansard. There is no reference to these words in the official record of Hansard. And there might be a very good reason for this. It is because crosstalk is not usually recorded. The reason for this is that the fact that members who feel threatened and or intimidated and or demeaned and or degraded by crosstalk have an immediate duty to bring the impugned words to the attention of the chair. This immediately triggers the jurisdiction of the chair and places the offensive words on the record. Procedurally, when attention is drawn to offensive words and the member accused of making the offensive remarks has one of two choices. He may A, dispute the words, or B, he may accept the words. Whichever choice he makes, there are consequences to follow. In either case, he may be liable for a breach of privilege if the words meet the threshold. In the case of A, if he disputes the words and is later found to have said it, it constitutes the offense of misleading the House. In the case of B, if he accepts having said the words and refuses to withdraw the words and apologize for same, he is still subject to the regulatory regime outlined in Standing Order 55. The problem in the instant case is that there is no actual video capture of the Honorable Attorney General uttering the words. The Honorable Attorney General has not taken ownership of the words, and there is no evidence that it is the words of the Honorable Attorney General. It is just an unidentified person's voice in the background. In the absence of a certified recording, this is unreliable evidence. The procedural misstep is that in the haste to bring the complaint, the members simply sought to reproduce words from a social media clip rather than seeking the advice of an experienced lawyer like Port of Spain South and going through the certification process. However, there's another dimension to this issue. Words by themselves, ipso facto, are not punishable in a summary fashion. The words must be likely to create disorder. It is beyond dispute that no complaint was made and no disorder ensued. In fact, there's an equally competing inference that if indeed the voice purporting to be that of the Attorney General is real, and it was him, this could have been a private conversation directed to no one. Think for a moment, members, and all of you are guilty of going on your phone and checking your email. And for a moment, in a moment of unexpected anguish, you open an email and you blurt out an expletive. And it's picked up on a hot mic. Think for a moment the consequences of that. Think for a moment, what are the consequences of that? And that's why the offense is not a strict liability offense. There are two dimensions. The member has alleged entirely without evidence that the words were directed to an elected member of the House, and furthermore, that it would have led to harassment and intimidation. There is simply no evidence of that. No attempt was made to particularize which member those words were directed to. As a consequence of that, it offends against a primary rule when complaints are made. When a complaint is made, it must contain material particulars. This is an elementary principle which is engaged when any process with potentially penal consequences is engaged. It also is beyond doubt that a reference to the Privileges Committee carries both reputational risk and also that of loss of property rights, suspension without pay, and other potentially penal consequences. In these circumstances, I again make reference to the ruling of the Honorable Barendra Sinanan, the November 28 ruling, where he outlined the factors and outlined the standard and burden of proof. In these circumstances, it is critically important that members seeking to make complaints must take care to identify the clear parameters of their allegations and also to provide facts which are supported by some reliable and credible sources of evidence. An overly lax evidential approach could have the deleterious effect of complaints being based on less than reliable and credible sources of evidence. No attempt was made to actually source the official recordings or transcript. Indeed, the words complained of do not appear in the transcript, the reason for which I've previously explained. And an overly lax approach will open the floodgates to persons out there scoring every single second of parliamentary time for hot mic conversations. And we will then be inundated with frivolous complaints of privilege, which may have been months old. Further, the complaint alleges that the words were directed to an elected member. That, in accordance with the ruling of Speaker Symon, constitutes an essential ingredient in the complaint. As I've said before, there's absolutely no evidence of this. Particulars must be supported by facts. There are no facts to support the material allegations of the complaint. As such, this complaint as well does not meet the threshold. Having said that, members, I want to say that the privilege of sitting in this House places on you a responsibility to conduct yourselves in moderation, order, and decorum, and such a manner to exemplify a productive and respectful debate to the citizens of the country. Going forward, can I implore all members to please exercise caution. If you want to have a private conversation, please turn off your mic. It occupies a lot of time in dealing with these matters. Thank you very much. I so announcement still. I ask all of you to join me in welcoming to the Chamber the participants of the Advanced Parliamentary Development Residency Program, which is being hosted by this Parliament of the Republic of Trinidad and Tobago in collaboration graciously with the Commonwealth Parliamentary Association. The program runs from December 8 to 12, 2025, and the participants include members of Parliament from throughout the Commonwealth. We also have amongst our guests the Honorable Alvina Reynolds, President of the Senate of St. Lucia. We say welcome to them all. Urgent questions?
Urgent questions.
No, we move to urgent questions.
So is this a point of order, Prime Minister? Mr. Speaker, point of order, please. Mr. Speaker, on today's order, people, may I draw your attention to Prime Minister's question. In accordance with Standing Order 26.1, and it reads as follows: during the second sitting of the House, each month, there shall be Prime Minister's question time at the time designated in the order of business. Before urgent question, may I draw to your attention, Mr. Speaker, that we have Prime Minister's question, and the Prime Minister is not in the chamber to answer questions and to account on behalf of the government of Trinidad and Tobago.
Let me hear both sides. Leader of Government Business.
Mr. Speaker, I did give notice to the Honourable Chair earlier that we were asking for Prime Minister's questions to stand down for later in today's proceedings. I want to remind my colleague from Aruka Lupino that while in government, several instances the opposition agreed to have Prime Minister's questions stand down later in the proceedings. So this is no deviation from the practice of this House, Mr. Speaker. And the Prime Minister will be here shortly to answer the questions. She was at another event earlier and she is prepared to answer today's questions. So it is disingenuous of my colleague opposite, knowing fully well that when they were in government, that this occurred on several occasions.
Is there a new point you wish to make?
Yes, please, Mr. Speaker. Mr. Speaker, I'd like to draw your attention and the House's attention to Standing Order 19, from which there can be no deviation unless a specific procedure is followed. Standing Order 19 reads as follows: Order of business. Unless the House otherwise directs, the business of each sitting day shall be transacted in the following order. So, Mr. Speaker, no amount of screaming and carrying on by the member for Couva South changes the standing orders. Also, to try and mislead not only those in the chamber who are visitors, but also those who may be looking on. This was not invoked on several occasions, and on occasions when it was attempted to be invoked by previous houses and previous parliaments, there was put to a vote as to whether it could happen or not. What we are witnessing, Mr. Speaker, is an obvious attempt by the Prime Minister to get more time to answer questions.
For the Spain South North, that is a clear violation of 48.6. It's a clear violation.
And House.
All right, I don't require, Labre, please, I don't require your assistance. I'll be very grateful for some silence. It is a clear violation of 48.6, and you know it. You're an experienced lawyer. 48.6 says, no member shall impute improper motive to any member of the House. When you say that the Honorable Prime Minister is deliberately absent from the House for the oblique and improper purpose of buying time to answer questions. Hang on a second. We're having a very tempered exchange. I don't wish it to escalate into anything else. Okay? It is a clear and palpable violation of 48.6. I'd require to withdraw that. We have done it in the past, where Prime Minister's questions have been deferred, and it has been agreed on both sides. Okay, well, if it doesn't agree, we'll take it to a vote. It's as simple as that. All right, the question is, honorable members, that the time... All right, let me just, before I do this, let me just... as a precursor to putting the question to the House, right? I just want to point out that this is an instance where strict adherence to the letter of the standing order is being demanded. And when it is inconvenient on one point, I'm being employed to employ a wide discretionary power, which when I say I don't have, I'm being told. But I just want to make that observation. So I propose to put the deferral of Prime Minister's questions to the House for a vote. I will go through the charade of doing that and waste more time. That's a matter entirely for the members of this House. Honorable members, the Leader of Government Business.
Thank you, Mr. Speaker. Mr. Speaker, I wish to invoke Standing Order 122.1 and to say that the disgusting behavior of my colleague from Port of Spain,
Leader of Government
North
Business.
St. Anne's West, will not be tolerated in these circumstances with respect to the vile conduct and comments he made with respect to the Honourable Prime Minister. You can't tell me to sit down inside of this house.
Business. Let's have some order. Leader of Government Business. Yes, have a seat. I'm going to deal with it. All right. Let's just invoke the standing order. Let's just invoke the standing order in a sterile manner and take the vote. And let's move on. Please. I'm of the view that 122.1 doesn't apply. Let's just put the question and take the vote.
May I ask you to look at 122.2, Mr. Speaker?
120. Yeah, but the precursor to it says 1 day notice. I would prefer, my preference is we simply put the question and take the vote. Okay. Honourable members, the question is that the time allotted for Prime Minister's question be deferred until later in the proceedings at a convenient time. Those in favour say aye. Aye. Any against? The ayes have it. Prime Minister's questions are deferred until later in the proceedings at an appropriate time. Not, I'll just ask you to withdraw the imputation of the improper motive, please.
There's no need to apologize. I withdraw the motive.
Urgent questions.
Member for Diego Martin West.
Thank you very much, Mr. Speaker. Through you, to the Minister of Homeland Security. Given the recent kidnapping involving 2 citizens at Monas Island, can the Minister indicate what immediate measures have been implemented to safeguard the public and prevent similar kidnappings?
Minister of Homeland Security.
Mr. Speaker, and to answer the question for the member for Diego Martin West, the Trinidad and Tobago Police Service, who has a responsibility to protect and serve with pride, at this time, they are coordinating operations with the Trinidad and Tobago Coast Guard in specific areas considered vulnerable. And as a result of that, their intentions are to protect the citizens in and around those areas considered vulnerable. But also, and it includes to safeguard the Republic, the public of Trinidad and Tobago, and to prevent further incidents of that nature. Also, Mr. Speaker, my colleagues on the other side, Aruca Lopino, Port of Spain South, they should have known that they left the Trinidad and Tobago. Developers, I object.
Up to now, you ain't answer the question. Damn it, man.
Sit down.
Sit down.
Okay. For the Spain. I'm standing by, allowing all of you all to indulge in this glorified juvenile behavior in the presence of parliamentarians from across the Commonwealth. For the Spain South. All right. Minister, could you just stick to an answer and leave out the unnecessary hyperbole?
Mr. Speaker.
Minister, that the 2-minute time period is up.
Okay. I'll take.
Member for Ruka Lopino.
Thank you very much, Mr. Speaker, for recognizing me as a supplemental question to the Minister. Minister, having regard to your response to the question posed by my colleague from Diego Martin West, can you state with particularity the interventions made by the Trinidad and Tobago Police Service to safeguard citizens in the Western Peninsula?
Minister.
I think I would have already answered the question, Mr. Speaker.
Diego Martin Central.
Mr. Speaker, I wish to draw to your attention Standing Order 29.5, which states, the Minister question shall rise in his place and give his reply, which shall be strictly relevant thereto and shall not exceed 5 minutes. Mr. Speaker, nothing in the answer from the Minister has been relevant.
Diego Martin Central is 29.5, applies to questions on notice. So the 5 minute, Diego Martin Central. Could I have some silence, please?
Correct.
Diego Martin Central, if perhaps you would have taken the time to read the standing orders on question time. There's a sliding scale, okay? 26 is Prime Minister's questions, 27 is urgent questions, 28 is questions on notice for oral answer, 29 is questions for written answer. The written answer requires a 5-minute period. The 2-minute period only applies to urgent questions. So, having done that, was that a point of order or a question you were asking? I'll tell you why I asked you that, because you would have saved Diego Martin Central, because that would have been the second question. But I'm going to exercise my discretion and give Diego Martin West his second question. Diego Martin West.
Thank you very much, Mr. Speaker, for your discretion. To the Minister of Homeland Security, what specific maritime assets and radar surveillance were active in the Gulf of Paria at the time of the abduction, and why did they fail to detect or intercept the perpetrator's vessel?
Minister, that's an entirely different question from the primary question. It doesn't relate to the primary question. I'm not permitting it.
Public business, government business bill, second reading.
Honorable Attorney General.
Mr. Speaker, I beg to move that a bill entitled An Act to Amend the Summary Offences Act, Chapter 1102, and for other related matters, be now read a second time. Mr. Speaker, the Summary Offences Act, or ordinance as it then was enacted more than 100 years ago in 1921. At that time, it punished behaviors. I'm not sure what's going on with my mic this afternoon. I usually put it on. especially for crosstalk. At that time in 1921, it punished behaviors that were considered to be abhorrent in the agrarian society that we then were. Livestock, fish, stealing and damaging of livestock, injury to each other, which stopped short of fatality. Those were matters that were covered by the original act. The more serious offenses against persons were covered in the Offences Against the Persons Act in 1868. The Act has been amended several times as the nature of the problems faced in our society have changed. Today, we seek to amend to regulate the use of fireworks. Fireworks have become an expected component of most types of celebrations in Trinidad and Tobago. From public holidays such as Independence Day and Diwali, to significant dates such as Olia's Night, to private weddings, birthday parties, sporting events, carnival fetes, one sees fireworks being discharged. The problem is that while they add to the spectacle for those celebrating, there are often serious and deleterious effects to persons in close proximity and surrounding areas. Mr. Speaker, the government is not against fireworks simpliciter, fireworks as a whole. But we can all agree that they can be a nuisance at times and that they can pose a threat to limb and life on occasion, and property. They can be harmful to the well-being of our families, especially those with health conditions, to our children, to our babies, and they pose serious threats, as I've said, to property and to animals. The fact is, fireworks are not toys. They are explosive devices capable of causing injury, distress, and damage to property. The Environmental Management Authority, the EMA, in its 2021 position paper on the management of fireworks in Trinidad and Tobago stated that, and I quote, "Fireworks are explosive devices that produce beautiful visual effects when ignited." This is the EMA speaking. Unfortunately, they also release destructive blast waves of compressed air, toxic chemicals, loud sounds, which harm the health of humans, animals, and the environment. What the government does today is to place some structure and order to what has been an entirely unregulated activity. As it stands now, anything goes. There are no requirements for permission, there are no requirements for proper handling, and there are no requirements which govern where and when fireworks can be discharged. The unchecked growth of the fireworks industry in Trinidad and Tobago has reached a dangerous point. What was once a source of celebration has over the years become a serious public safety concern. Over the years, we have read countless reports of injuries caused by fireworks. These are not isolated incidents. They are recurring tragedies that highlight the very real dangers of treating explosives as entertainment. Each report is a reminder that fireworks are not just harmless fun, but hazardous devices that demand control to protect citizens, animals, and property. This government has taken note of the situation and has brought this bill to address the issue. Mr. Speaker, I wish to refer to just some of the incidents which have been reported in our newspapers. In the Newsday of the 27th February 2003, it was reported that several patrons had suffered serious injuries at a concert in Chagaramas, which many of us still remember, when a burst of fireworks, instead of shooting into the sky, arced into the crowd, setting fire to a number of persons, injuring them, and I believe it was a Marshall Montano concert. It was a tragedy. No one died, but a number of persons were seriously injured. The Trinidad Express reports that on the 11th of November 2015, a 56-year-old man lost several fingers on his left hand when fireworks that he was setting off exploded on Diwali night. So you have burns in one case, lost fingers in the other. On the 17th of November 2017, a grandmother was injured when an unidentified man threw a lighted scratch bomb inside of her son's car. It blew up in her hand, severing pieces of her fingers. Again, injury to the person. And then there was a fatality recorded in East Port of Spain on the 1st of January 2017. Now, in January of 2023, at least 3 businesses on the corner of Nelson and Duke Street in Port of Spain were set on fire earlier Saturday morning due to the misuse of fireworks. That was described as a fireworks war. And most recently, and this report was truly heartbreaking, in the Saturday Express of the 25th October 2025, a mere 6 weeks ago or so, it was reported that a newborn baby had passed away. Her parents believe that the child's death was triggered by the fireworks. I'm not a coroner. I make no conclusion on this. I'm reading from open source information. Vulnerable citizens, including the elderly, children, and those with medical conditions, suffer from the excessive noise and disruption. Animals, too, are affected. Homes and businesses are at risk of catching fire if fireworks land on them. Beyond these immediate damages, there are other possible risks which fireworks pose. They pose a grave national security risk. Their explosive components can be repurposed to construct improvised bombs, while their deafening blasts often mimic gunfire so closely that they may mask the illegal use of firearms. And there have been a number of occasions in which this has occurred. The evidence is clear, Mr. Speaker. Without regulation, fireworks jeopardize not only our celebrations, but our collective security and well-being. The risk, nuisance, and threat to public safety associated with them provide sufficient reasons now for the use of fireworks to be controlled. The government promised in the lead up to the election and has since then demonstrated by action that we intend to deal with the rampant lawlessness that has occurred in our society. We made it clear that we seek to restore order to Trinidad and Tobago. And lawlessness does not just refer to criminal activity, violent or white-collar crime. It speaks also, quite literally, to a lack of laws and regulation to treat with various aspects of social and economic activity. Failures of the state which allow people to act outside of the law and to exploit gaps in regulation. This government has a zero-tolerance approach to disorder, and we are determined to ensure that we safeguard all of our citizens and that we tend to the well-being and health of all of our society as a whole. We intend to do this by bringing timely and relevant legislation to the Parliament, by empowering and resourcing law enforcement, by strengthening the judiciary, and by protecting victims of crime. We have been working assiduously to create the appropriate regulatory frameworks for various sectors which have been allowed to grow and develop unchecked with no oversight over the past decade. In so doing, we draw clear boundaries between what is legally permissible, what are beneficial activities, and on the other hand, what are illegal, prosecutable offenses. We are closing doorways for exploitation and harm to others, particularly the most vulnerable, while creating a foundation for growth and for peace and our overall well-being. The government believes that this is a critical and timely piece of legislation that strikes the correct balance between the rights of the individual and the overall good of the society. Mr. Speaker, the Law Reform Commission, pursuant to its statutory mandate, undertook a review of the laws governing fireworks in response to mounting public outcry some 5 years ago. In 2020, they produced a policy paper entitled Fireworks, a Review of the Law. The policy that they sought to convince my friends on the other side to pursue included the following. One, it asked them to explore the scope of the current legislative framework governing the industry and the role of enforcement authorities. Two, to examine the major issues surrounding the recent growth in the industry, including the increasing availability and use of fireworks. Three, to examine fireworks regulations and enforcement measures in other jurisdictions, such as England, Canada, Australia, and the Federated States, New South Wales, Queensland, and South Australia, and in New Zealand. Mr. Speaker, arising out of the Commission's work, three principal concerns with respect to the use of fireworks were identified. The first was risk and danger to life and property. The second was high noise levels causing this disturbance. The third was misuse and deliberate use of fireworks for criminal purposes. The Commission subsequently furnished recommendations in relation to the use of fireworks, which could be achieved in the short term, and prepared a bill entitled the Summary Offences Amendment Bill of 2021. That's 4 years ago. What did they do?
Nothing. Nothing. As usual. Nothing.
Arima, you were not there. I do not blame you. In January of 2022, the Commission advanced the 2021 bill by the conduct of public consultation. They went out for public consultation. They sought written views of the public, and that was not a symbolic gesture. It was a deliberate effort to ensure that the voices of citizens and institutions were heard. Key stakeholders, such as state authorities, NGOs, members of the public, were all invited to submit written comments. The process yielded invaluable insights, reflecting widespread concern and offering practical recommendations. What did they do?
Nothing. Nothing.
The usual, nothing. The Commission, recognizing that reform was imperative and that the law should be modernized, made certain recommendations to us. They're as follows. One, they suggested that we regulate the use of fireworks by introducing a new permit requirement. Two, they suggested that we prescribe the times on public holidays and on December the 31st for the use of fireworks without a permit. Three, they suggested that we restrict fireworks from being discharged within a half-mile radius from specified places such as hospitals, homes for the elderly. The Cabinet felt airports were important, registered animal shelters were important, and the Commission had already suggested that we protect the zoo. They also suggested that we make fireworks offenses ticketed offenses through the issuing by the police of fixed penalty notices. They suggested that we restrict the use of fireworks to persons 18 years old and over. And finally, they suggested that we provide that a video recording captured on a mobile phone, tablet, iPad, or other similar electronic or smart device shall be admissible as evidence. In order to give effect to these recommendations, the government has moved with haste, given the time of the year, to bring this bill which has been languishing for 5 years, to the House this afternoon. I should like to turn to the bill itself. By introducing a permit requirement, the bill ensures that fireworks are no longer freely accessible without oversight. Permit holders must notify the fire service before use, and that creates some accountability and transparency. Clear exceptions are outlined alongside restrictions and fixed penalties for breaches, ensuring that enforcement is practical and effective. The bill empowers the Minister of Homeland Security to craft regulations to give full effect to these provisions, while also modernizing enforcement by allowing recordings from cell phones, smart devices, to be admissible as evidence, with 6 clauses requiring only a simple majority vote. the legislation is both measured and achievable. And if I could just take the House through the main provisions in the bill. Clause 1, of course, is the short title. Clause 2 seeks to provide that the Act shall come into operation on such date as is fixed by the President by proclamation. That allows us to deal with the immediate problems, well, not problems, but the immediate celebrations before we go to the other provisions in the legislation. Clause 3 seeks to provide for the interpretation of the amending law. Clause 4 contains a definition of fireworks and of toy fireworks. Some of these definitions do not create new legal concepts. Rather, they draw directly from established provisions in existing law, but by incorporating terms already recognized under other law, the bill ensures consistency, avoids ambiguity, and strengthens the overall framework for regulating fireworks. Mr. Speaker, I should like to emphasize that within the definition of fireworks, we have deliberately recognized and included the category of noise-reducing fireworks. This inclusion is not incidental. It is a conscious effort to mitigate the harmful effects that traditional fireworks inflict on both people and animals, and it may be that we return to that at another time. Clause 5 of the bill seeks to amend the Summary Offences Act by repealing sections 99 to 101 of the Act and substituting new sections 99 to 101(1). Mr. Speaker, in many other jurisdictions, the supply and sale of fireworks are governed by rigorous and highly detailed regulations. We in this country must now ask ourselves, why should our standards be any less stringent when the dangers we face are just as real? In addition to requiring authorization to sell fireworks, the regulations in most jurisdictions restrict the types of fireworks which can be sold to the general public, impose age requirements on the sale and purchase of fireworks, specify permitted periods during which fireworks can be sold or displayed for sale, and impose requirements on fireworks sellers. What we propose in section 99 is simply to provide that a person shall not discharge fireworks unless he holds a permit issued by the Commissioner of Police. The proposed section 100 then provides for the general provisions for permits to be granted to use fireworks. These provisions would include, inter alia, the type and amount of fireworks, the location, date, and time of use. In most jurisdictions, the purchase, acquisition, and possession of certain types of fireworks are strictly prohibited. These restrictions are not arbitrary. Ours are carefully designed to promote consumer safety and to protect the wider public. By ensuring that fireworks are entrusted only to responsible individuals capable of handling them safely, over 18, these laws reduce the risk of accidents, safeguard communities, and uphold the principle that celebration must not come at the expense of security or well-being. Mr. Speaker, the proposed section 101 introduces a safeguard. Persons who now wish to discharge or use fireworks would be required to notify the fire service of any intended use of fireworks. So once you apply to the Commissioner of Police and you obtain a permit for the discharge of fireworks, you must then notify the fire service of the intended use of the fireworks. The provision is not a mere formality. It is a vital measure to ensure preparedness, to protect lives, and to minimize risk. By mandating prior notification, we seek to empower the fire service to anticipate potential hazards, respond more effectively, and to uphold public service. The proposed section 101A establishes vital restrictions on the use of fireworks. It addresses the discharge of fireworks on land and ensures that such activity does not create danger or nuisance to others. Equally important, it mandates the supervision of children when discharging toy fireworks. The proposed section 101B introduces essential restrictions on the use of fireworks in close proximity to sensitive areas such as hospitals, national parks, registered animal shelters, and the zoo. These measures are necessary protections designed to end the unregulated, irresponsible, and inconsiderate use of fireworks that has caused harm for far too long. Mr. Speaker, the proposed section 101C recognizes and balances the cultural significance of fireworks by allowing their discharge without a permit on specified days, namely public holidays and New Year's Eve. That being said, there are specific windows of time in which fireworks can be discharged on these days. For public holidays between 8 and 9, on the 31st of December from 11:30 to 12:30, the next day. The provision strikes a careful balance as it preserves the tradition of national celebration within clear parameters. In this way, the law respects our heritage of festivity, yet maintains the safeguards necessary to protect citizens, animals, and property from irresponsible or unsafe use. The proposed sections 101D to 101H provide for a fixed penalty notice to be issued where an offense is committed under the proposed sections 99 to 101C. These proposed sections also provide the following: A, payment of the fixed penalty notice; B, filing a notice to contest the fixed penalty notice to the Criminal and Traffic Court; C, proceedings to be instituted where the fixed penalty notice is not paid; D, the interpretation of certain terms used in sections 99 to 101G. Mr. Speaker, one of the most critical aspects of regulating fireworks is ensuring that the provisions governing their use are properly enforced. Legislation without enforcement is ineffective, and enforcement must be both practical and robust. As in Trinidad and Tobago, police in other jurisdictions bear the responsibility of prosecuting individuals who use fireworks contrary to law. The proposed section 101L is another important provision of the legislation. It empowers the minister to make regulations that give full effect to sections 99 through 101(7). This authority is not simply procedural, it is in fact essential to ensure that the framework we establish can be properly enforced. Regulations are the mechanism by which administrative and regulatory procedures will be put in place, allowing the law to move beyond principle into practice. Without them, enforcement would remain fragmented and ineffective. Finally, Mr. Speaker, Clause 6 of the bill introduces a consequential amendment to the Evidence Act to provide that video recordings captured by new technology, mobile phones, tablets, iPads, other similar electronic devices, shall be admissible as evidence. This is a practical and forward-looking measure, recognizing the reality that in today's world, the most immediate and reliable evidence often comes from everyday technology in the hands of ordinary citizens. By modernizing the law in this way, we make enforcement, evidence gathering, and prosecutions less complicated and more effective. The amendment strengthens accountability, ensures that breaches of the law can be more easily proven, and empowers both authorities and the public to play a role in safeguarding our communities. It is a simple yet powerful step toward ensuring that justice keeps pace with technology and promotes respect for the rule of law. Mr. Speaker, in view of the fact that this or similar legislation has gone to a joint select committee before, under the tenure of my friends opposite, in view of the fact that the public consultations were held during their tenure, in view of the fact that they drafted legislation to bring about precisely this, I expect their full, unconditional support this afternoon. Mr. Speaker, I thank you and I beg to move.
Before I put the question for debate, honourable members, I propose to revert to an item which we deferred to later in the proceedings. Clerk.
Minister's questions.
Member for Port of Spain, North St. Anne's West.
Thank you very much, Mr. Speaker. Mr. Speaker, question number 1 to the Prime Minister, the member for Siparia. Would the Prime Minister advise how many written commercial offers for gas supply, which include volumes of gas to be supplied, price of the gas, and length of contract beyond 2025 and for longer than 6 months have been sent by NGC to the petrochemical producers to date, and for which companies?
Honourable Prime Minister.
Thank you very much.
With due respect to the member for Port of Spain South, Port of Spain North, St. Anne's West, I know the minister would have been Minister of Energy for many, many moons in his last reincarnation, and therefore I'm very surprised, or maybe I should not be surprised, that the minister would ask a question like this. The minister knows that these commercial contracts are all tied up, these contracts, with confidentiality agreements. Confidentiality agreements. Mr. Speaker, I've been reminded that would be Law 101, first year law, that the minister should well know, having served in that ministry. So the details of the gas contracts, negotiations, both on the Speaker, you gave a brilliant ruling. It was well reasoned. So let's not have that again, please. The banter and the crosstalk from let Port of Spain North control himself, please, sir.
Member for Ruka Lopino.
Thank you very much, Mr. Speaker. To the Prime Minister. Oh.
What the question? I beg your pardon, Honourable Prime Minister.
So Port of Spain North, St. Anne's West well knows that these contract negotiations, both on the upstream and the downstream, and the terms being negotiated, are the subject of strict obligations of confidentiality between the parties. If the member is not aware of these obligations, clearly it represents the reckless manner in which such negotiations were undertaken by himself and the past administration. My government respects our obligations to our downstreamers and upstreamers. We have no intention of breaching contractual obligations, and when these negotiations are completed, public statements will be made by all parties. I thank you, sir.
We will revert to supplementals when the Standing Order Committee does its work. And for the avoidance of doubt, I want all the members to know that I have the Hansard for the actual deliberations of the committee when Standing Order 26 was granted. And as I said, I'm more fortified in my view. But I don't want to get in. That's an old debate. Let's move on. Aruka Lopino.
Thank you very much, Mr. Speaker. To the Prime Minister. Can the Prime Minister state the reason or reasons for the former CEO of WASA being sent on administrative leave?
Honourable Prime Minister.
Honourable Speaker, Honourable Member and members, the last acting CEO of WASA was never sent on administrative leave. So the premise of this question is a false premise. Therefore, the question does not arise. That person tendered his resignation, citing personal reasons. So it's a false premise that the question is based.
Mr. Speaker, to the Prime Minister, can the Prime Minister provide the name of the person who was appointed Acting Chief Executive Officer of the Water and Sewage Authority?
The Prime Minister.
Thank you, sir. The person who was appointed to act as CEO of WASA is a person who is or was or still is an employee of WASA, and his name is Mr. Dane Maraj. Thank you.
Okay. That concludes the question. I now propose, honourable members, to put the question for debate. Honourable members, the question is that a bill entitled An Act to Amend the Summary Offences Act, Chapter 1102, and for other related matters be now read a second time. Member for Diego Martin Central.
Thank you, Mr. Speaker. Thank you for recognizing me and allowing me to contribute to the debate of the Summary Offences Amendment Bill 2025 before us today. Mr. Speaker, before we start, I think it is important that we acknowledge the fact that with the greatest of intentions, this matter is extremely polarizing in today's society. And no matter what is decided here today, there will be persons who say that anything that is done to limit the use of fireworks will be seen as overreach by the government and an authoritarian approach. Yeah, it was a little rough there, member. Approach by the government. And there will be people who say that unless the government implements an outright ban, that they have done nothing to appease the issue. Mr. Speaker, it is against the backdrop of that polarizing nature of this topic that the government that I was a part of engaged in a lot of work that looked at both the drafting of legislation, the creation of policy, the acceptance of policy papers created by the Law Reform Commission, going out to public consultation alongside members, hearing the opinions of those members of the public and stakeholders in the industry. And that work, Mr. Speaker, this bill stands on. So, Mr. Speaker, any building, no matter how grand or how simple, requires a foundation. That foundation was built and laid by the People's National Movement. And in coming here today, the UNC government is coming with the final brick. But that final brick, Mr. Speaker, speaks to this aspect of fireworks as a general industry and the way in which fireworks is utilized and role that it plays in our society. Mr. Speaker, the Law Reform Commission's paper, as identified by the Attorney General in his piloting, was an extensive paper. It not only spoke about the use of fireworks, but spoke about every aspect, not only of the industry, but of the life cycle of fireworks in general. And it is our hope on this side, even as we do say that we are minded to support this bill, that we do support the intent of this bill. We hope that this bill is a part of a suite of legislation that does introduce regulations across the industry to ensure that best practice and world standards apply to the industry beyond simply the use of fireworks in general. So, Mr. Speaker, yes, we are minded to support the bill, but we also intend, as an opposition,
all right, the noise in the...
The speaker talking to you.
Well, I'm also speaking to you as well. So let's take it down a notch. I don't think there's anything controversial here.
Thank you, Mr. Speaker. So, Mr. Speaker, even as we are minded to support this bill and its intent, we also acknowledge the role and responsibility of the opposition in this Parliament, and to do our part to improve it, to strengthen it, and to legislate with responsibility, or to acknowledge our part in legislation with responsibility and respect for the people who must live with the consequences of this legislation, Mr. Speaker. So, Mr. Speaker, the PNM, having long recognized the need for regulation in the fireworks industry, and understanding that this bill did not start with the government, the creation of the bill did not happen in a vacuum, and that the bill stands on the hard work that the PNM did while in government. It did, Mr. Speaker.
Let's take down the temperature a bit, shall we? As I've said before, these are largely uncontroversial provisions. Really shouldn't engender this kind of response. So let's take it down a notch.
And Mr. Speaker, it is that work that led, as I said, to policy drafting, to draft legislation that it is the bill that has been brought before us today is 95% the same, identical to the PNM's draft legislation. But Mr. Speaker, it was the understanding that this legislation by itself is not the only answer, and that it does require a broader look at the industry itself. And that was why, when the legislation was brought to Cabinet, it is why when the recommendations from the Law Reform Commission were brought to Cabinet, they were sent to FNGP, and a subcommittee formed under FNGP in our time was created to look at this policy paper, look at the recommendations, and to ensure that those recommendations, if implemented or changed, would be in the best interest, not only, primarily yes, but not only of the citizens, but of the industry as a whole, and the way that it impacts the fabric of our society. So, Mr. Speaker, I can tell you that when it was brought before that subcommittee, that included Minister of National Security, the Attorney General, Minister of Agriculture, the Minister of Public Administration, and myself. I was in favor then of regulation. I am in favor now of regulation. And that is because, Mr. Speaker, the welfare of citizens of this country is not only my first concern, but it is the opposition's first concern. Mr. Speaker, and as I said, that is why we are minded to support the bill today. We say that we are minded to support it because much of the work sits on the work that we have already done. However, Mr. Speaker, our support does not mean silence. And our support doesn't mean that we will give up our constitutional duty to scrutinize legislation brought before us. So, Mr. Speaker, I would like to say that the Attorney General and I agree that fireworks have become a part of our cultural fabric. And it is because, Mr. Speaker, when we celebrate as a people, we celebrate loudly, we celebrate joyously, we celebrate with a level of vibrance that is world-renowned. And so maybe that is why fireworks have fitted so seamlessly into the way that we celebrate. So Christmas, yes, Diwali, yes, Old Year's Night, yes, Carnival, yes, weddings, yes, birthdays, yes. Independence Day, despite the fact that it was official celebrations were cancelled this year under the government, those all form part of celebrations in this country in which fireworks have become an almost integral part. But Mr. Speaker, I also agree with the Attorney General that while fireworks do bring us joy, they do in some cases bring profound distress to many people in this society. And we have heard numerous stories from across this country, from St. Joseph to Pinal to Diego Martin to Port of Spain, where persons have died, have been grotesquely injured, where dogs have been killed, where farmers have lost their livestock. We have heard enough of these stories to say that this is a bill worthy of support as a starting point. So, Mr. Speaker, I can tell you, I understand from a personal standpoint what it is to be a new parent, to have a newborn lying in bed, and that newborn screaming at 2 and 3 in the morning because fireworks are going off and it sounds like it's just outside your door. I can only imagine the heartbreak that would be felt by a parent who would have lost a child and honestly believes that that child's death can be attributed to fireworks. Mr. Speaker, it goes to the elderly in our society. It impacts children with autism and other sensory sensitivities. And as I said, Mr. Speaker, it impacts homeowners who are pet lovers, and it impacts the farmers of our society. In short, Mr. Speaker, we have communities that are robbed of quiet, they are robbed of comfort, and they are robbed of peace. And many of those persons in our community, Mr. Speaker, are not calling for it to be banned. There are some that may want this totally banned, yes, but many of them are not calling for it to be banned. What they are asking for is for fireworks to be used responsibly and for there to be rules for order and for basic respect. And regulation, in our opinion, is how we strike that balance, Mr. Speaker. So, Mr. Speaker, we agree with the government on the permit system. We agree that fireworks cannot continue to be discharged without oversight, and that a permit system will establish accountability. It will encourage responsible use from the law-abiding. It will protect vulnerable groups, and it can create an environment where citizens can enjoy fireworks without creating chaos. And a citizen who intends to obey the law will have no issue applying for the permit as the bill prescribes, Mr. Speaker. However, it is those who intend to skirt the law whom we must be concerned with. Mr. Speaker, at section 101B, I believe, we agree with the restrictions on sensitive areas. The bill protects hospitals, it protects the zoo, it protects national parks, forest reserves, and farms with animals, and we agree that these protections are long needed. Mr. Speaker, it should not be that as a matter of course, a baby in a neonatal ward, a premature baby in a neonatal ward, should have her fragile sleep shattered because of a free fall with fireworks. It should not be that the parents who are there are also filled with anxiety and trauma because of the distress that their child is in. So, Mr. Speaker, we do agree that in this sense, those protections are necessary. Mr. Speaker, when it comes to the fixed penalty system, we also agree with that. And it sat, as the permit system did, it sat in the legislation that was drafted under the People's National Movement. But, Mr. Speaker, we agree that it does enforce. It does modernize enforcement. We agree that it will reduce court delays. We agree that it gives police, or it should give police, a practical and immediate tool. And I will speak to that in a little bit as well, Mr. Speaker. And we do agree that it should encourage compliance through deterrence. Well, Mr. Speaker, the opposition supports this, but would suggest a change at 101E4 to extend the time to pay from 14 days to 28 days. Mr. Speaker, in the best of times, 14 days could be considered onerous for someone, especially as we do not know what the fine will be because it is not in the legislation. The average person may find that onerous depending on when the ticket has been given to them, to be able to pay that until month end. But, Mr. Speaker, obviously, this has been exacerbated simply because of the economic situation that we are facing in this country right now. And we do believe that the impact of moving this time to pay from 14 days to 28 days would make it less onerous and would definitely encourage buy-in from the public. And Mr. Speaker, this bill, as I have just given one suggestion, and Mr. Speaker, the opposition may circulate amendments that will speak to these issues.
We'll consider. You're suggesting a change to 101C, Section 101, Clause 101C. Is that the suggestion you just made? 101. 101E. One moment, please.
Fix the period for payment of the fixed penalty notice from 14 to 28 days.
Fix the
payment
moving
period.
from 14 days to
28.
Certainly, we will consider it at the committee stage. Thank you very much.
And Prime Minister, we acknowledge and thank you for your consideration. So, Mr. Speaker, we are getting into the conversation around how this bill can be strengthened, because the opposition does want the bill to be on implementation to have an effect. If we don't do that, Mr. Speaker, this simply becomes words on paper that will have no real effect on our society. So, Mr. Speaker, as we are speaking about that, and we are talking about citizens who contravene the law should not be held accountable beyond what is reasonable. Mr. Speaker, we also would like to suggest to the government that they do reinstate or integrate, however you want to look at it, key oversight agencies in this process, and I will explain why. Mr. Speaker, restoring the EMA, the AG spoke to them at the very opening of his piloting, restoring the EMA, restoring Civil Aviation Authority, and restoring municipal corporations into the permitting process is not adding bureaucracy, it is adding oversight to the permitting process. Mr. Speaker, the EMA was addressed specifically in the Law Reform Commission's paper, and it was referred to because they are the agency with the responsibility for noise pollution. Mr. Speaker, besides that obvious fact, fireworks, again, as the AG said in his piloting, fireworks do contain chemicals, they do contain heavy metals, they do contain particulates, and they can affect air quality and wildlife. And the EMA would help assess and mitigate those risks, and in our estimation, their involvement is essential. Mr. Speaker, nothing in this legislation restricts the times that fireworks can be discharged other than on public holidays and on December 31st. So we do think that there is a requirement for the agency who is in charge of noise pollution to have an active role in that permitting process. And even where you have the situation of time controls, what you are actually doing is condensing the time in which that noise will take place. So again, we do think the inclusion of the EMA is critical in this, and we hope that the government will take that suggestion. Mr. Speaker, the Civil Aviation Authority. Mr. Speaker, this bill creates a half-mile radius within which there can be no discharge of fireworks in specific areas, and one of those areas is airports. But fireworks can rise hundreds of feet in the air, and they can interfere with approach paths, they can interfere with departure paths, and they can affect low altitude navigation. And from the information that was presented to me, Mr. Speaker, the fireworks can also create temporary radar clutter through false echoes and distortions, which can be caused by the very metallic particles and smoke, and they can affect pilot visibility. And, Mr. Speaker, of course, Beside the obvious impact on arrival and departure paths, we know that the government would not want to jeopardize the equipment that they have recently had placed at Crown Point. And Mr. Speaker, according to a pilot that I spoke to in the lead up to this debate, there is no such thing as a minor aviation safety concern. So the opposition is of the position that we believe the Civil Aviation Authority of Trinidad and Tobago, their involvement is also absolutely necessary, especially as it pertains to the areas in and around our nation's airports. Mr. Speaker, municipal corporations, they in their districts will know where the homes of the elderly are, where the maternity homes are, where convalescent facilities are, where chronic care institutions are. They know the terrain, they know their communities, and they will know the best places for the discharge of fireworks and those areas where it will be dangerous. Mr. Speaker, one of the gaps in this legislation is that even as we look at areas that need to be protected or where fireworks, the discharge of fireworks should be prohibited, it does not address the discharge of fireworks in residential areas which may or may not be densely populated. Mr. Speaker, the inclusion of the municipal corporations in the process will ensure that permits are reviewed with on-the-ground knowledge and not in a vacuum. Again, we do not think that this is an obstruction. We think this is coordination, and we think that it does strengthen not just the legislation, but the effect of the legislation. And Mr. Speaker, there was one issue that I'm hoping that the AG will clarify in his winding up. The bill protects private hospitals under the Private Hospitals Act. Now, that is one of the differences between our draft legislation and the bill that the government has brought. And in the Private Hospitals Act, that definition includes homes for the elderly and maternity homes, and they are expressly identified. However, there are two issues here that do bring me some concern. Mr. Speaker, where you have homes for the elderly that have less than 5 persons, what happens there? And also, are hospices also covered under this definition, or the use of the definition in the Private Hospitals Act? And Mr. Speaker, I raise that because most citizens will not understand how those definitions work. Most citizens are not going to be privy to that sort of cross-referencing that takes place in our legislation. So to most citizens, they will look at a home for the elderly and say, well, that will look like a hospital. They will look at a maternity home and say, well, that will look like a hospital. And without education, people may violate this law unintentionally. Mr. Speaker, for this law to work and for it to work well, the public must understand where fireworks can be discharged, what penalties apply, what facilities are protected, and most importantly, Mr. Speaker, because of the polarizing nature of this legislation, they have to understand why the rules exist. There is a segment of this population that we accept will oppose the bill. We accept that, Mr. Speaker, and those are the ones that the government and everyone here who is an elected representative must concern themselves with, because the goal should not be to fine people into submission. The goal should be to get public buy-in, and for this not to be seen as yet another revenue-generating initiative on the part of the government. So it requires, Mr. Speaker, a national education component, and I understand that that would not be in the legislation itself. I am just speaking as a member of this House who genuinely wants to see this legislation work. So, Mr. Speaker, it is about building a culture of responsible enjoyment. So that the bill, nothing in this bill stops someone from enjoying fireworks. They can still celebrate. They can still do it, but now they have to do it responsibly. And they have to do so with regard for their neighbors, and they have to do so with regard to vulnerable communities. But, Mr. Speaker, we have to ensure that the legislation does not create spaces where either there are groups of people who cannot do that, or there are groups of people who are still impacted by the misuse of fireworks. And I believe, Mr. Speaker, that education is key to achieving that, and municipal corporations, in particular, with their local knowledge, must be partners, have to be partners in that public education effort. Mr. Speaker, I want to draw you to an article in the Newsday dated Sunday, 23rd November 2025. And the headline is Culture Minister, Carnival Venues at Queen's Park, Savannah and Chagaramas. And the first paragraph of the story, Mr. Speaker, how much time do I have?
Again, but would you require 15?
I will, Mr. Speaker. The first paragraph reads that the government has earmarked areas within the Queen's Park Savannah and facilities in Chagaramas as alternative sites for Carnival 2026 events following a sweeping ban on fetes at major public sporting facilities. And, Mr. Speaker, it refers to comments made by the minister during a sitting in the House on November 21st. Mr. Speaker, under this bill, the ability for fetes, the ability for our celebrations for Independence Day will be threatened. The ability to have those types of events will be threatened. Simply because the Savannah sits between two zones that are protected. It sits between the zoo and it sits between the Port of Spain General Hospital. And so, and private hospitals. And, Mr. Speaker, the Savannah is not alone in that. There are locations within the country that sit in zones like that, particularly when it comes to hospitals. So, Mr. Speaker, that location of the Savannah in that disputed zone does create an issue for our Independence Day celebrations. And, Mr. Speaker, beyond the Savannah, the use of Chagaramas also creates an issue because large portions of the Chagaramas Peninsula are used as our forest reserve. So if it is that we are saying to our fete promoters at Carnival time, which is right around the corner, if we are saying that you cannot go to certain venues, national sporting facilities, but we will allow you to go to the Savannah or to go down to Chagaramas. But under the legislation, we are saying that those areas, you cannot use fireworks. We are not acknowledging the fact that in those fetes, fireworks and pyrotechnics are part of the experience in those parties. And, Mr. Speaker, I believe the Promoters Association referred to the ban on the facilities as a death knell. What I would not like us to see is legislation coming to this House that puts a further nail in the coffin of an already vulnerable sector. So, Mr. Speaker, we are saying that there is, or we would like to see, some sort of a structured approval mechanism for national celebrations and cultural events, particularly in areas where those events will be held in or in close proximity to prohibited areas. But, Mr. Speaker, it will also be useful for the government, if it is their intention to continue this long celebrated national tradition of fireworks in the savannah, to create a level of certainty around it, not just for the organizers, but for the patrons as well. So, Mr. Speaker, we do think that, that this will add value, but, Mr. Speaker, that is also taking into account that the minister does have wide powers available to him to circumvent sections 99, 100, and 101 and issue exemptions as he may see fit. However, Mr. Speaker, our position is that this protects the minister from the argument of bias. It says there is no introduction of, well, you gave promoter X and you didn't give promoter Y. And it, again, encourages a level of certainty around promoters and event organizers. And we do think that if that process is open, if it is transparent, that it aids both all promoters, organizers, and patrons to know that their events are not going to be jeopardized by this legislation, Mr. Speaker. Mr. Speaker, enforcement. No matter what we say here, this, as I said before, this legislation will simply be words on paper if it is not enforced. And enforcement is also addressed specifically in the Law Reform Commission's paper. So we have to confront a reality. We have to confront the reality that most citizens are going to follow the law. Most citizens are going to apply for permits. They are going to comply. They are not the problem, Mr. Speaker. The challenge lies with those who do not intend to comply, who will believe that they could circumvent that law and nobody will come for them and that sort of thing, and those who knowingly discharge fireworks illegally and cause harm without any consequence to them, or believing that there will be no consequence to them. And the law, Mr. Speaker, must be designed to address them, not the law-abiding citizens, but the citizen who believes that it either doesn't apply or they will not get caught. And that brings me, Mr. Speaker, before I continue, it brings me to the section 6 of the bill. Clause 6 of the, thank you, colleague. Clause 6 of the bill, where the Evidence Act has been amended, and has been amended to allow for a video recording recorded by means of a mobile phone, tablet, iPad, or any other similar smart device shall be admissible as evidence, and then further that the definition for information system is changed by inserting after the words generating the word recording. Mr. Speaker, I don't know how effective this will be. Firstly, it will be after the transgression has taken place. Secondly, there's nothing here that I think does not allow for altering of videos for AI or for videos that are taken on some other day purporting to be on the night of the infraction itself. So I am not certain as to how this is going to improve enforcement. And also, Mr. Speaker, it seems to me that in the inclusion of this clause, it now shifts, it transfers the responsibility from the state to the citizen for monitoring themselves, putting it in the hands of the citizens to say, well, my neighbor is doing this, or the person up the street is doing that, and here is a picture or video that may or may not be true. Mr. Speaker, I strongly believe that enforcement in this sense has to be visible so that the deterrent effect is immediate. It has to be consistent so that nobody feels exempt. It has to be timely so that no violations do not get addressed in real time. And it has to be coordinated so that gaps between agencies are closed. We've already said that we know when the peak fireworks periods are. The dates are no surprises to any of us. It is the same every year: Independence, Diwali, Christmas, Old Year's Night, Carnival. But these are not days of celebration. Very often they are seasons of celebration. So it does require the municipal police, again, leveraging for the inclusion of our municipal corporations, and the TTPS to have a presence in our communities during these periods. Not to intimidate, Mr. Speaker, but to reassure law-abiding citizens and to deter those who would intend to break the law. So I think, Mr. Speaker, if you pair this with the National Education Program, the pathway to compliance does become clear, does become accessible. Mr. Speaker, enforcement should not be intended to punish joy. It should be there to protect peace, and it is meant to ensure that those who wish to celebrate can do so without violating the rights of others. Mr. Speaker, there are two other issues, and the Attorney General did speak to it, and I would just like to address it briefly. Mr. Speaker, the use of fireworks starts with the purchase of fireworks. And nowhere in this bill have we discussed the purchase of fireworks. And the requirement, Mr. Speaker, because there is a level of ambiguity there. Does the person who is purchasing the firework need to present a permit in order to purchase? Because we could have permits from now until kingdom come. If I could just go and purchase fireworks, then what we are doing is undermining the very legislation that we intend to improve our society. And also, Mr. Speaker, again, the Law Reform Commission's review was wide-reaching and broad. It required a level of discussion, a level of deep dive that was not going to be done in a short period of time because it impacts so many people in our society. And one of those issues here, Mr. Speaker, is about the regulations for sale to minors. The legislation speaks about a permit not being afforded to a person under 18 years old. But the sale of explosives, which is what governs that in our country, not fireworks, the sale of explosives, at this stage of where we are right now as a society, that sale is prohibited to persons under the age of 16. And if the bill is $200, the fine is $200, Mr. Speaker. So, Mr. Speaker, I would like to see whether the Attorney General speaks to it in his winding up, or we do see, as we go forward, legislation that does treat with these issues that I think directly impact the actual use, the responsible use, and the use by persons who should be old enough to use fireworks. Mr. Speaker, as I started off, the opposition supports this bill because it reflects the work that we have already begun. We support the intent of the bill because we do believe, as in the legislation that we drafted and forms the vast majority of the bill that is in front of us now, we believe that all stakeholders' views have been considered, that protections that are in there that we have already championed, and that there is a national need that is recognized in the bringing of this legislation. We support it, but we support it with responsibility. We support it in principle. We support it with a firm commitment to improving the lives of all our citizens. And if strengthened along the lines that we have outlined, with proper oversight, clear protections, strong enforcement, and national education, we believe the legislation can bring the relief to persons as they deserve. It can protect the vulnerable, preserve national traditions, and it can support cultural industries, and it can allow citizens, Mr. Speaker, to enjoy fireworks in a way that is responsible, respectful, and safe. And with those words, Mr. Speaker, I thank you.
For the Spain South.
Mr. Speaker, if the truth is told to the public, we cannot oppose a legislation that we drafted ourselves. This is our legislation. And I will answer the question why it was not brought as yet. Because, Mr. Speaker, as a government then and as an opposition, we are responsible and we understand populists and a populistic approach as opposed to, Mr. Speaker, an approach that understands that we are a plural society in Trinidad and Tobago with competing interests dynamically operating all at the same time. So, if the government was serious about implementing this legislation before Christmas, where are the regulations that are a precondition of this bill, Mr. Speaker? Where are the regulations as it relates to the licenses, as it relates to the applications, as it relates to the form, as it relates to the penalties? And if those regulations are in the hands of the Honourable Member for Tunapuna, we'll be here a long time. We do not oppose. We do not oppose, and we are not here to reject this. But I ask the Honourable Attorney General, before this version, and I call it a copy and paste version of the draft 2021 PNM bill, where were the consultations that preceded the presentation of this bill by this government? Mr. Speaker, for example, and there is a juridical concern we have about this amendment and the bill that has been presented. Let me go directly to it, Mr. Speaker. Mr. Speaker, when you look at Clause 6, which purports to amend the Evidence Act to now make it admissible that you can have video recorded evidence in a court, here is what it says. The Evidence Act is amended, and you go to B2, right? A video recorded by means of a mobile phone, tablet, iPad, or other similar smart device shall be admissible as evidence. Mr. Speaker, where are the evidential safeguards for this legislation? You would know that the Miscellaneous Act that amended the Evidence Act makes it possible for CCTV footage to be admitted as evidence in court. But there are safeguards. Before you admit the CCTV footage, you must say, at the time in question, the device was working properly. This is the time and date. We checked it to see if there were any bugs, and we then, therefore, we authenticated the veracity of the recording. Mr. Speaker, you just ruled on a matter where you said there is no evidential foundation because all you had was an oral recording. Even though you heard a voice, and the voice would have come from a person, you said, where is the Hansard to back it up? R fortiori, where's the video? In this amendment that is suggested, where are the safeguards that will make the foundation of an evidential substrata to say the iPhone or the device was working, there was no tampering with it, at the time in question, this is the date, this is the time, this is the place, and most importantly, Mr. Speaker, you want to establish that there was no AI intervention, there was no photoshopping, as was done in several instances. How do you prove who took it, when they took it, what was the circumstances of it? And this is the evidential quagmire that this amendment, this clause, has inbuilt in it, Mr. Speaker. When you have a video recording, Mr. Speaker, that is admissible, and it is now mandatory, it says shall be admissible without the safeguards. What happens then when the test, because this is obviously, this part of the legislation is relative to enforcement. Where are the legal safeguards? What is the evidential burden? What will be the standard? Would it be on a balance of probability? Would it be beyond reasonable doubt? What will that be, Mr. Speaker? These are issues that we think this clause 6 ought to be totally excluded and thought out properly, if at all, and brought in a form that is palatable with the laws of Trinidad and Tobago and our judicial standards. And in this regard, we put a marker on this proposed clause that seeks to amend Section 12 of the Evidence Act, particularly, Mr. Speaker, in light of the recent development of AI technology. We now come to the gravamen of our discourse in supporting this piece of legislation. We say that in a society that respects the views of others, that there is a creeping concern of segments of the society that there are implementation of rules and regulations that attack or address a certain diaspora. We want that everybody in Trinidad and Tobago have the right to enjoy their properties in a quiet way. But we also say that people must not feel that they're being disenfranchised. And that is why we say the necessary groundwork, the building of consensus to see that this law fits the realities of our country was not done. And that is why also, Mr. Speaker, that the People's National Movement, although drafting this bill, we hastened slowly to make sure that we got it right. Maybe that's a fault of ours. We've tried to get it perfect all the time. But governing Trinidad and Tobago is not an easy task, and you have to address competing interests. Because people, we say, must have a voice in the laws that govern them. And it is a democratic obligation. It is not a favor. And if it is, Mr. Speaker, that you take a populist stand, not understanding, not reading Professor Lloyd Bradford, Professor Carrington, to understand that there's a plural society that emanated from a plantation society. So we must understand that, yes, there's a balancing interest for persons who are affected by the fireworks, but also that fireworks and its uses form a part of the tapestry of our existence in Trinidad and Tobago, and particular the East-West Corridor. It seems that there's a concentration, Mr. Speaker. It seems, and I will expound on it, Mr. Speaker. The cancellation of FETs, the double taxes on alcohol, the cancellation of sponsorship.
Mr. Speaker, please. 48.1, the member is now speaking about the cancellation of FETs and alcohol and the diaspora and so on.
Port-au-Prince South, I'm imploring you, let's skip along a little bit, shall we?
Mr. Speaker, the point I am making does not offend 48.1 respectfully, because I am showing how this bill, I am not challenged, how this bill could be part of an artillery. Correct. An artillery. And on this side, we continue to stand in the gap. So we also say, Mr. Speaker, that the measures must not be seen, and the perception must not be that measures are aimed at particularly targeting perceived PNM constituencies. That's the point. That is the point I am making. And I make it to say, Mr. Speaker, I make it to say that I use that submission and I use the evidence, or I use the events, Mr. Speaker, about the activities.
48.6. Targeting, that the government is targeting a certain demographic that he's referring to.
Look, in the spirit of cooperation as we've been getting along with this bill, I'm going to give a little leeway, but I'm going to ask Port-au-Prince South if we could continue. You know how to sterilize your contribution, right?
Speaker, after the intervention of the Honorable Minister of Defense,
you know, there are several ways I could respond to that, which I will sterilize my tongue and not respond to. So let's move on.
So what I say is this, that we have to be a little cautious, and in the perception, Mr. Speaker, I'm not accusing, I'm saying a perception. And it's a creeping perception, Mr. Speaker. We understand governance, but governance and reigning must not be perceived to be at one segment. That's the point I'm trying to make. And as we support this legislation, Mr. Speaker, that is why we flag our concerns. And an additional concern that we have, Mr. Speaker, relates to the clause 5, 92.2, and we would like to be added to that, apart from that being, and may I find it, Mr. Speaker, so I can be more specific. 92.2, Mr. Speaker, speaks about the application going to the Commissioner of Police. And you make an application, a person shall not discharge unless he has a valid permit.
Is it
99. 99.1.2, sorry, it is correct. 99.1 and 99.2. We are proposing, Mr. Speaker, the addition of an online permit application, which may tend to make the process less cumbersome. So after 99.1.2, we are proposing a 99.3 that reads that an online permit application system will be established under this system. That may cure the backlog from the Commissioner of Police and give people an opportunity to make an application online, and may make doing business less cumbersome. Also, we also take, and Mr. Speaker, I don't want to be accused of tedious repetition, but the issue of the removal and the leaving of the fire service as the only referable entity in this is of serious concern, particularly as it relates to the municipal corporations, Mr. Speaker. And we are asking, Mr. Speaker, respectfully, that they reconsider the removal of the 3 entities, and at least because the EMA has said that it does not have the teeth. In the report, we have done our homework, and we have read the report coming out from the Law Commission. The EMA in that report has said that they do not have the teeth or the remit to do the enforcement of fireworks. I may not agree, but they have said so we understand that. But the Civil Aviation Authority must have some input and some relevant input in this issue, and also the relevant municipal corporations, because they would know, Mr. Speaker, better than anyone else the topography of the municipality within which the firework is being discharged, or within which the request for the permit is being made. So we think it is relevant, and we are asking at least that they consider, the Honorable Attorney General at the committee stage considers the re-inclusion of Civil Aviation Authority and the EMA and the municipal corporation. Mr. Speaker, we have spoken about the extension from the 14 days to the 20 days. And what really it is, Mr. Speaker, is a traditional, it's akin to or sibling to a stay of execution. And in a stay of execution, you never get 14 days, Mr. Speaker. You start at 28 days. We prefer 42, but we understand it's law enforcement. So we are asking the Honorable Attorney General to consider.
Mr. Speaker, 55(1)(b), this was already said, and our Prime Minister also said she would look into it.
All right. I think, all right. Remember, I think the member is giving a rationale for it that has not been previously explained, so continue.
Speaker, and the rationale. Mr. Speaker, sometimes I think I'm in the twilight zone when I hear some of the objections. Mr. Speaker, the 28 days, more importantly, and Mr. Speaker, apart from that, there is included there in that clause a provision that allows for a time frame, and I would want to read that clause, Mr. Speaker, into the Hansard. We would want to also advise, Mr. Speaker, that as it relates to the latitude given, that it goes, the outer limit would be the 42 days, as the other times that may be prescribed. We are suggesting that because I think that it makes a little more sense, and it will account for finality in these proceedings, as opposed to when you are paying it, or if you are paying, and, Mr. Speaker, bring an end to the time frame allowed where you say, look, I'm not going to pay, I'm going to contest the fixed penalty notice. So we are asking that that time frame be specified to the outer limit of 42 days. Now, Mr. Speaker, as I continue, the other aspect of this bill that is of some concern to us is that we wondered about the fireworks regulatory system that does not seem to be in place. This bill focuses primarily on the use of fireworks. And while the regulation of its use is important and significant, and we acknowledge that, it ignores sale, distribution, and storage of the fireworks. And that we say is critical, and these are critical areas that affect public safety and market accountability. Mr. Speaker, the storage of fireworks is something that must be regulated if it is that public safety is a primary concern, and I ask the Honourable Attorney General to consider that and bring appropriate legislation in order to account for that. And that is why the job, as Voice said, we were far from finished with this legislation. We also propose that all vendors and importers be properly licensed with clear requirement for the storage, record keeping, and inspection. And the enforcement officers have the authority to seize unprotected and unsafe storage of the fireworks. That is something that we say is important, and we ask that that be given consideration, particularly fireworks that are sold illegally or stored illegally. It ensures a full regulatory framework for the sale of fireworks, from the selling process to the display process. The removal of the critical oversight and notifications I have dealt with, and to say, Mr. Speaker, that the oversight that we asked for were to deal with air safety, environmental noise and wildlife, fire hazard, and local community management. And we say that that is a critical issue, and we say it has not been adequately dealt with, and we ask for consideration to be given to that. Now, Mr. Speaker, I have not heard from the Honourable Attorney General, and we are going to suggest an amendment, and maybe in his wrapping up, which should come soon, he would explain to us why was the Civil Aviation Authority removed when fireworks routinely reach altitudes that intersect with low-flying aircraft. We would want an explanation, Mr. Speaker, for that removal, because it seems to our simple minds to be counterintuitive and against the policy behind the proposed legislation. Although the bill is forward-thinking, and that's because it was PNM drafted. This is our bill, you know. This is our bill, you know. The checks and balances that have been removed weakens the safety. You have it. And it weakens the safety and protections. Moreover, Mr. Speaker, the 20, I just want to say, and I will edify the honourable members on the other side, in the drafting of the 2021 bill, we considered and understood the severe impact that fireworks may have on wildlife and livestock. And whilst the 2025 bill still mentions sensitive areas, by removing the agencies that are linked to these areas, it has weakened the teeth of the bill. And we say it's a backward step in the law, and it's a backward step from what was originally proposed. Mr. Speaker, I now go to classification and safety. It is my respectful opinion that we need, there may be a need, and we need to have some consideration of it, for the classification of fireworks by hazard levels. That is the international standard, distinguishing between toy fireworks, consumer outdoor fireworks, and professional display fireworks. This would allow safety standards permitting an enforcement, and the enforcement of the legislation would be tailored appropriately and it will protect citizens and users, and it will reduce the risks throughout. Also, the issue of the noise control, we see it is there, and we think that that is a forward step in the future usage of fireworks. Mr. Speaker, under the heading of expansion of exemption days without the proper safeguards, we are of the opinion that the 2021 bill allowed fireworks without a permit only on public holidays, New Year's Eve, with specific time restrictions. And on New Year's Eve, for example, the 2021 bill permitted fireworks between 11:30 and 1, providing a reasonable window for celebration. In contrast, the 2025 bill maintains these exemptions, and the window for New Year's Eve is only from 11:30 to 12:30. While this might seem like a small change, it marks a shift towards expanding exemptions without adequate safeguards and reducing the flexibility of the 2021 bill, which still strove to ensure public safety, and that is a concern that we have. The penultimate concern, Mr. Speaker, I have two more: permits and the notice period. The bill requires permits for the use of fireworks issued solely by the Commissioner of Police. What it has done, and this practice, it centralizes permits, and that is impractical, particularly during peak periods of the use of fireworks, such as Christmas and Carnival. And we are advocating a delegated permit system, along with the amendment that we are proposing to circulate with the online application. That may take the burden off of one office holder and may make doing business a little easier. The notice period for firework displays is currently 14 days, which is insufficient for large events. We are proposing maybe an extension of that to, again, the 28 days, giving both the authorities and the organizers adequate time to plan and adequate time to address safety concerns. So it is something that we ask be considered relative to the notice period, not being 14 days, but 20 days, which would augment the period of notification and allow the persons involved, well, now it's just the fire services, but the organizers and also the residents, because they may want to hear from the residents, they may want to hear from the homes, they may want to hear from the interested parties their views. 14 days may not be an adequate period, so we are asking Honorable Attorney General for the consideration of an augmentation of that to 28 days. Mr. Speaker, there are cultural considerations. Under this bill, no permit is required for fireworks on public holidays on New Year's Eve. We say Carnival is arguably the largest cultural and tourism event in Trinidad and Tobago and is not included in this exemption, despite the fact that fireworks are central to main Carnival events. Any legislation that ignores Carnival risks cultural alienation and disruption and may lead to the bottom line, economic loss. We ask Mr. Speaker, I checked to see what were the exemptions and if Carnival was included as a festival or an event. It's not. We really may need Honorable Attorney General to consider that, because it is part of our tapestry. It is part of how we live, and we are asking that that be considered. The enforcement penalties and education, we do support enforcement mechanisms, including fines for breaches, but we would recommend a graduated penalty system as it relates to the fact that repeat offenders should maybe face increased penalties including imprisonment for serious recidivists. We stress the importance, and the honourable member from Diego Martin Central did education. I can't better that submission, and I want to commend him on his erudite rendition of the education. I want to commend him on that. I say no more. Mr. Speaker, I go back to clause 6, which I will ask for 9 minutes of my 15 minutes, Mr. Speaker. Clause 6 of the bill, it really is a bothersome clause. And I will not go into the technical aspect. Well, why not amend the act? Because I suspect when they say it's amended, it will be amended in the act itself. So it's not, you don't need a standalone. I had a little cognitive dissonance, but I got around it, so I understand it. You all will not understand cognitive dissonance. But what is being said here, yeah, they wouldn't even understand cognitive. What happens, Mr. Speaker, while the bill introduces consequential amendment to the Evidence Act that allows video recordings from mobile phones and tablets as admissible, Mr. Speaker, it raises privacy concerns, it raises procedural concerns, it raises concerns as it relates to persons. What about the person who is being recorded? If that person takes objection, that may lead to a fracas. It may lead, Mr. Speaker, to it may very well lead, I don't want you to tape me, get out of my space. That may be a legitimate response, especially if you go on the person's premises to tape it. What happens? Stand your ground? Stand your ground. Stand your ground. Wow. Stand your ground, people. So they see the fireworks, Mr. Speaker. You take up your device, and you move on the person's premises. And here the nice part about it, Mr. Speaker, if we follow some of the rationale from Toko Sandy Grande, when the person done tape and they're going back, you know what they put, and they turn their back, bullet. Bullet. Mr. Speaker, this is a clause that is of serious concern, particularly if the video is taken without the consent, Mr. Speaker, particularly as it relates to chain of custody and unclear and ambiguous guidelines for admissibility. A change of this magnitude really, Mr. Speaker, and I understood my dissonance, it really requires a standalone compendium clause in the Evidence Act, which will deal with process, procedure, admissibility issues as contained in the Miscellaneous Act. So, Mr. Speaker, here is what we say. We do not oppose in print. Mr. Speaker, I really would like to make my presentation in silence. Please, I beg you, Mr. Speaker. Thank you.
Go ahead, I think it's stopped.
Mr. Speaker, we do not oppose the regulating of the fireworks. As we say, that's our brainchild, the PNM. Well done. Well done, PNM. It focuses, well done, yeah, well done, well done. But this bill in its current form, it focuses narrowly on use, ignoring sale, distribution, and storage. It centralizes authority excessively in one office holder, that is the Commissioner of Police. It requires practical adjustments to permit notice periods. It needs classification of noise and safety standard that is lacking. It requires public education and transitional provisions that have not been provided. And most importantly, my last 2 points, it lacks and lacked meaningful consultation and it fails, Mr. Speaker, to account for carnival and major cultural events in Trinidad and Tobago, which shapes our plural society, and that is the concern. So in those circumstances, Mr. Speaker, we ask that the amendments we propose be considered respectfully, considered at least.
Are you sitting next to Nakayin?
Wow.
At 10. Let him finish in peace.
Mr. Speaker, we ask that that clause 6 be revisited in its entirety. We ask that the proposed amendments that we have circulated, be given serious consideration, particularly the online application system. We ask that the 14-day notice period be extended to 28 days, but the penalty, most importantly, the time to pay the penalty, we ask that that be augmented from 14 to 28 days. And in taking my seat, Mr. Speaker, I would want to commend the work of the People's National Movement, and honestly, Mr. Speaker, because with all that, the AG brought it, and we support it today. Thank you, Mr. Speaker.
Remember, it's 4:26. It's just 4 minutes shy of the usual tea break. But I propose to take the tea break now, and we return at 5:15. This sitting is suspended until 5:15. Thank you very much. Honorable Prime Minister.
Right, sir. Thank you, Mr. Speaker. I joined this debate on the, just to put it shortly, what we're calling the fireworks bill, really, but it's an amendment to the Summary Offences Bill. Summary Offences Act. If I may spend a few moments, Honourable Speaker, to put this into context, and I think this is a very important piece of legislation for Trinidad and Tobago, because when we look at the history, we would see that this has been a burning issue for our citizens. So first, this bill has been shaped by years of trauma, public advocacy, expert reviews. I endorse all the comments made by the Honourable Attorney General in response, and who else would? All right, just the AG thus far, so I endorse the statements made by the Honourable Attorney General. This bill, sir, I believe, speaks directly to rights with respect to peace, safety, dignity, and quiet enjoyment of your homes, of your property. In just 7 months in office, we have brought what I think is a landmark piece of legislation to reform and finally regulate the misuse of fireworks and to address in part the issue of noise pollution. And I was just speaking with the Honourable Minister of Homeland Security and the Honourable AG. We will come back to this House in the new year with legislation about noise pollution generally, but this is just one aspect of that. Now, the fireworks, evidence shows us very clear, they are not just beautiful, harmless things, not just for entertainment. They raise national public health, safety, security, and mental well-being issues as well. They have allegedly been linked to the tragic death of a 3-day-old baby. They're responsible for deaths, severe injuries, traumatized children, terrified animals, hospitalizations, fires, burned homes, other properties. Warnings have come repeatedly from TNTEC, from the EMA, from medical experts, teachers, animal welfare groups, and communities across our land. Hundreds of citizens have written letters, editorials, petitions, begging for action. But for almost a decade, those pleas have been ignored, and the law remained unchanged under the former government. Today, my government seeks to correct that failure by bringing this bill to Parliament. We bring it to help restore order, protect the vulnerable, and to safeguard community well-being. The bill is especially urgent as we enter the Christmas season. Of course, the New Year is coming up, and Carnival as well. So when fireworks sometimes are used, as I say, in a very reckless, harmful manner. So we legislate to ensure that nights of chaos become nights of calm. Celebration should no longer mean terror for babies, the elderly, animals, persons with disabilities, and so on. A nation long forced to endure many, they can finally breathe, knowing that the government listened. This is responsible governance, this is compassion, and indeed it is justice long overdue. And can I say, Honourable Speaker, that we are very proud to bring this bill. This is yet another promise made and another promise kept in record time. So, Mr. Speaker, regulation of fireworks has become a very serious concern for us, a growing national concern, driven by risks to public safety, risks to national security, animal welfare, public health, infrastructure, and peaceful enjoyment in communities. In response to mounting public pressure, Mr. Speaker, back in the day, the former PNM regime was compelled to publish something known as the Summary Offences Amendment Bill 2022 on the 7th of January 2022, and with consultations closing 26 January 2022. That draft attempted to arrest short-term recommendations from the Law Reform Commission. The Law Reform Commission did a working paper, and in this paper, Mr. Speaker, named Fireworks, a Review of the Law, dated April 2020. We are now in 2025, where we seek to address the concerns that were then raised by the Law Reform Commission. The Commission's review was triggered by increased availability of fireworks and reports of psychological harm, animal injuries and deaths, fires and explosions, disruption to vulnerable citizens, infrastructure damage, unplanned power outages, and national security concern. The LRC, meaning the Law Reform Commission review, also noted that fireworks contain explosive materials which can be repurposed to create improvised explosive devices. Very important in this time of concerns about national security. Let's look at the legal context. And before I go there, I want to mention this bill that my colleagues on the other side had brought in, I think it was 2022. So the existing law in the Summary Offences Act, in particular sections 99 to 102, they were considered by the recent reports and deliberations of the LRC, and they were considered to be outdated and ineffective. That is the ones in the 2022 document. On March 15, 2017, so this dates back now, March 15, 2017. Who was in office? We were in office. Sorry, this is 2017. On March 15, 2017, under the watch of the former government, a joint select committee on social services and public admin was launched for an inquiry into fireworks, 2017. We are now in 2025. The final report of that committee into the adverse health effects of fireworks 2018 was that report and was laid in the House and in the Senate. In April 2020, the Law Reform Commission published a policy paper, which I mentioned before, Fireworks, a review of the law policy paper. The recommendations from that JSC report led to drafting of the bill I mentioned before, Summary Offences Amendment Bill 2021, the Fireworks Bill. So this has been in the works for quite some time, Honourable Speaker. In November 2021, the Summary Courts Amendment Bill 2021 was introduced in this House of Representatives. Today, under current law, fireworks may be discharged year-round, that's the existing law, year-round with minimal regulations and restriction. The legal framework is contained in about three pieces of legislation. Some are primary legislation and some subsidiary legislation. One, Summary Offences Act, Chapter 1102, and in this statute, fireworks may not be set off in a town, that's existing law, without written permission with a fine of $1,000. That's found at Section 99 of the present law. Outside towns, fireworks may not be discharged in a street or within 60 feet of the center line with a fine of $400, again, Section 100. Town is defined as including Port of Spain, San Fernando, Arima, and a 2-mile radius around each of these towns. The second piece of legislation, subsidiary, fireworks permit regulations made under Section 101 and 102 of the Summary Offences Law. Permits issued by the Commissioner of Police or a superintendent. Applications require 48 hours notice. There is no requirement for safety certification or competence. That's the existing law. And the third piece of legislation, under Section 5.2 of the Public Holidays and Festivals Act, the President may authorize or prohibit certain fireworks during festivals. Under aviation law, directing fireworks at aircraft sites carries a $10,000 fine and 1 year of imprisonment. At the time of the LRC review, 2025, no legislation existed to regulate the sale of fireworks. And I heard my colleague on the other side, one of my colleagues, mentioned nothing about the sale. What happens at the sale? It would be Port of Spain South mentioned it. Yes, Port of Spain South, yeah. About at the sale, at point of sale, how do we deal with it? So the LRC recognized that there was no legislation in place. There was no legislation regulating the sale of the fireworks. There was nothing about operator training or certification. There was nothing about storage. There was nothing about traceability. There was nothing about accountability. And there was nothing about professional display standards. So the LRC again got to work. The Summary Offences Amendment Bill 2025, which is the one before the House now. Let me commend the Honourable Attorney General and his team for bringing this forward in rapid time. I had committed that we will bring it before the end of the year. And promise made, promise kept, we're here again. An interesting exercise took place when the AG brought the draft bill to the Cabinet for approval. And at that Cabinet meeting, which was a bit unusual, but was very, very instructive, many members of the Cabinet contributed and made amendments at that point on the floor of the Cabinet, which have now been included in the bill. So in addition to the public consultations, the entire Cabinet had an opportunity to go through every clause, clause by clause, which in that sense tells me we have a better version of the bill before the House. So this bill contains a mere 6 clauses. This bill requires a simple majority, but I'm very heartened today, Chief Whip and Leader of the Opposition. Maybe it's a season of goodwill to all men. And I want to thank you for giving your support. And the amendments you're suggesting, we will deal with it at the committee stage and take them one by one. So I thank the opposition. I don't think this would have happened for some time, but today, in the season of goodwill, I want to thank you all very much for your suggestions. And not to say I'm lecturing the opposition, but really we are willing to listen. If it is you give us, amendments, we do not take the approach, no, nothing, we don't want to hear you. I give you that assurance today that we will try where we can to accommodate your suggestions and amendments. Some we will take and some we will explain why, and you will have to explain why you're putting these. So thank you again. So 6 clauses, simple majority. It provides for mandatory permits for discharging fireworks, except in narrow prescribed circumstances. Clause 5 of this bill before us creates a new section 99, which in effect says no person shall discharge fireworks without a permit issued by the Commissioner. Further, there are restricted zones in this bill. Fireworks are prohibited. This is clause contained in creating a new section 101B. This is to prohibit fireworks within a half mile of hospitals, within a half mile of airports, within a half mile of zoos, farms, animal shelters, forest reserves, and national parks. This is clause 5 of the bill. So we have restricted zones where fireworks can be set up. We also have limited exemptions without a permit. Clause 5 creates a new section 101C, which applies only on public holidays and on the 31st December, and there are time limits given there. Public holidays from 8 p.m. to 9 p.m., clause 5, and All Year's Night, which straddles the holiday itself of the New Year's Day, but All Year's Day is not a public holiday, but we straddle it in from 11:30 p.m. and All Year's Night, taking us up to 12:30 a.m. the next day. So this, I could say a little more about that, why we've done that. We have, I think it is 16 public holidays, if we include the New Year's Day, and looking for my piece of blue paper again, total hours. So we have 16 public holidays. We are now saying you do not need a permit to let off, what do you call them, send off fireworks on the 16 public holidays. You don't need to come for a permit now. So this is where we're seeking, as I say, to balance. And on those 16 holidays, I say which includes the New Year's Day, total hours for a year is 8,760. Fireworks, 16 hours, so we're looking at 8,744 other hours of the year, no fireworks. So again, it's a balancing. In our cabinet, we had a divergence of views. Some were saying, I won't tell you who they are, they were very adamant, no fireworks, no, 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 no. Then there were those, well, some of it. And perhaps because it's been part of our, from as long as I know myself, first time I saw fireworks was in 1962, 63, opposite my home in Superior at the park, the Superior Park, Irwin Park in Superior, and it was for independence, and that was the first time this marvelous thing known as fireworks that I experienced. To me then it wasn't noise, it was just some beauty. But since then we have had so many complaints and worries about what is happening, so we need to regulate it. So the number of hours when we'll actually have fireworks are very few, and the number of days, only 16 days of a 365 days in a year. So I talked about the use of the permits, so no permits for those 16 days, and those 16 hours basically, or 16 and a half hours for the year. Then we have introduced with this bill the fixed penalty enforcement, clause 5, which allows police to issue ticketable offences, and I take the point made by Port-of-Spain South it was, yeah, about changing the payment of the fixed penalties from the 14 days to 28 days. So we accept your recommendation in that regard. Fixed penalty enforcement allows police to issue ticketable offences, which sets out issuance, payment, contesting, and legal effect of these fixed penalty notices. The bill also seeks to modernize evidence rules, including the admissibility of mobile video recordings. Clause 6 amends the Evidence Act to recognize recordings from mobile phones and tablets as admissible. I note that the opposition is asking us, and we'll go into more detail at the committee stage, but is asking us to delete this clause, which provides us with another evidential angle to see if people are breaking the law or not breaking the law. So at the committee stage, we'll discuss and we'll take your rationale for deleting it. Initially, my response is I would not want to delete that because evidence is so vital, and given the technology in our day and age now, we should use it where it is. And I suggested to the AG we need to consider on a whole our Evidence Act, and Honourable Speaker, as a practicing lawyer in your past life, you would appreciate that we do need to make amendments to the Evidence Act. And this is what Clause 6 seeks to do, that we can use video evidence, all the other kinds of technology to help us to make that evidence admissible. So that was the Clause 6 suggested to be deleted, which at first glance we are not so inclined, but we stand to be convinced in the committee stage. Further, this bill gives us regulation-making power. The Minister of Homeland Security, just check if we have National Homeland. The Minister of Homeland Security, including permit revocation, additional enforcement provisions, and Clause 5 creates provisions for the Minister may make regulations to give effect to the Act. Again, I think one of the speakers on the other side, maybe the Honourable Member, Mr. Scotland, did mention about regulations. So we do have a regulation-making power within the bill so that the Minister can act upon that to take it further. Some suppliers, I mentioned again the sellers, have adopted voluntary safeguards, including age verification, know your customer records, and secure remote storage and traceability, which can now be formalized and strengthened through regulations made under this bill. Drafting and outcomes, LRC conclusions, sir. The Law Reform Commission and parliamentary inquiries confirm a long-standing pattern of harm and inadequate law with respect to fireworks. The LRC has reviewed fireworks laws since 2003, following escalating complaints intensified after the 2005 Port of Spain bombing and increasing nationwide use. The LRC 2025 paper, which we used to inform the drafting of this bill, assessed reform needs using comparative international law and evidence from the 2017 Joint Select Committee on Adverse Health Effects. Over the past 2 decades, fireworks have become common at Carnival, Independence, Diwali, Christmas, New Year's Night, and several other special occasions, so that some regulation has to happen. The LRC has identified for us, Honourable Speaker, 3 leading importers supplying the retail sector. There are 3. So if we are looking at dealing with selling, those who sell, these importers and suppliers of fireworks have been identified by the, let's say, the Law Reform Commission. We look also now at documented harm. The Honourable Attorney General mentioned some of them. We have press reports cited include severe injuries from malfunctioning displays at a concert, a 15-year-old losing his index finger, choir members burned at a hotel lounge, an infant with severe hand injuries, a 54-year-old losing 3 fingers, a warehouse explosion killing 24 people. A teenager died after a firework detonated in his face. May I share personal experience, Honourable Speaker? We were engaged in a big UNC rally in some previous years down at Mid-Centre Mall. And the attraction on the stage at the end when we all spoke was to be these fireworks, and they had stationed them on each side of the stage. And I'll tell you what happened. That hit me in my eye. I had to leave that stage and run down to a nursing home to seek, and I had, great discomfort, but I thank God that I did not lose my eyesight. Did not lose my eyesight. So here we have, I said, a teenager died after a firework detonated in his face. That led me off to my own experience here. Fireworks are classified as explosives and produce noise, light, smoke, and debris. So multiple petitions call for regulation, some for bans. The laws remain unchanged. Noise pollution was consistently identified as a major concern, affecting the elderly, the babies, the vulnerable, animals, wildlife, and so on. And so we come back to this bill. At hearings on the 15th March and 19th April in 2017, that's the former Joint Select Committee sitting, they heard that fireworks cause burns to the skin, burns to the eyes, burns to the hands, and of course any part of the body. They cause hearing loss, they cause amputations, and that JSC reported that scientific evidence shows that fireworks release sulfur dioxide, carbon monoxide, carbon dioxide, particulate matter, metal salts, all of which can linger in respiratory systems and cause harm. DMA confirmed traditional fireworks often exceeded 120 decibels, requiring nearly 1,500 meters to fall to the legal limit of 65 decibels, exposing entire neighborhoods to the ill effects. This was EMA testimony before that JSC in 2022, as recorded in our Hansard. National security risks included fireworks, mimicking gunfire, explosion, masking criminal activity, and enabling the construction of improvised explosive devices. Again, Hansard at the GSC report. Enforcement evidence showed weak statutory authority. Just 5 charges under that existing law in 5 years. And AG, you did say this has been there for what, 100 years maybe? The Act, 100 years has been in place. Most complaints occur during Diwali and Christmas. Witnesses are reluctant to testify against neighbors, and this is why that clause 6, which says you can tender videos and out of your social technology network, that can't be tendered because neighbors don't want to come and testify against their neighbors. Again, this is Hansard on the GSC report. Successful enforcement requires catching offences under the Act. I'm told that on the supply side, there are 3 importers existing. Can you give me a time check, please? There are 3 suppliers that these names came up. How much left? 24? Thank you very much. Can I get an end time? It's easier for me to calculate. Thank you so much.
So you have 5 minutes of regular time.
Of original time. Thank you. May I take the opportunity to ask for the extra time?
Yes, of course.
I thank you very much. So I'm saying on the supply side, we were told that there are 3 importers. I am also told, I'm advised, that 2 of these suppliers were compliant with something called biannual fire certification. So 2 were compliant, and 1 was not. Again, on supply, we are told these 3 exist, 2 compliant with biannual certification, 1 was not. Again, this is from the JSC report way back I spoke of in 2017. This evidence is documented in the official report of the JSC. The evidence appears in the section titled Regulation, Retailers, Importers and Storage Facilities, where the Chief Fire Officer and Ministry of National Security officials confirm 3 primary importers. The fire service conducted fire safety inspections twice per year on importers' storage facilities. Again, 2 complied, 1 did not. This evidence was entered into the parliamentary record. So again, through you, Honourable Speaker, Honourable Ministers with responsibility for national security and for the fire services, need to go back and check compliance matters in this regard. This evidence recorded, as I say, in the GSC report. Biannual certification is a requirement in law. Under the Explosive Act, Chapter 1602, and under the Fire Service Safety Storage Protocols, not statutory in a single regulation, but enforced through Fire Service Operational Policy. So that's a job for us on the government side, the executive side, that we need to check for compliance with the existing suppliers of the fireworks. So this may help with the mention made about the sellers and suppliers. So these inspections ensure compliance with proper storage distance, ventilation standards, fire suppression systems, and safety signage. Let's look at some of the legal gaps, Mr. Speaker, and let's look at international models, which we have looked at in crafting and drafting this bill. The LRC of 2025 concluded that TNT lacks a single governance framework, that regulation is scattered across multiple statutes and is outdated, that despite a legal age restriction, minors still purchase fireworks easily, especially from temporary roadside stalls, so there are no standards or oversight. There are no requirements for safe handling, no requirements for certification, no requirements for storage, no requirements for auditing, no requirements for professional display standards, and penalties remain weak and outdated. The EMA reported having no real teeth. This is recorded in the Hansard in that JSC report. The EMA reported having no real teeth for enforcement, and noise zoning is outdated. And to the members who are trying to get us to include the EMA, please convince us, because the EMA seems incapable of having teeth to deal with these matters. The Commission, that is the LRC, recommended a coordinated multi-agency enforcement model involving the TTPS, Customs, Fire Service, and the Forensic Science Center. Internationally, the models we looked at, we found two models in existence. Model A, full public ban. Some of my members would love to see that, but maybe in another lifetime. As I say, in another janam. So we'll consider it, as we come forward. So in some models, a total public ban of state-controlled displays. This is in Singapore, Northern Ireland, Northern Ireland and the Republic of Ireland, and in Chile. Model B, full cycle regulation. This is the Model B. Licensing, safety testing, notification requirements, and labeling. This is the model we have largely adopted to craft this bill. This model exists in Australia, Canada, England, New Zealand, and maybe some others, but these come readily to mind. Some jurisdictions ban fireworks above 120 decibels. So these are the two basic models. Our LRC 2025 rejected Model A for TNT due to economic and cultural impacts, and they warned it would drive smuggling. So you have a total ban, you know what happens? The smugglers, the black market comes into play. LRC warned against using that model of a total ban. Instead, the LRC, and by LRC I mean the Law Reform Commission, recommended Model B, supported by a national classification system based on explosive content, hazard level, and noise output, and they urged urgent implementation in the public interest. Their short-term recommendations included restrictions or bans on the noisy fireworks, regulation or prohibition of sky lanterns, and 30-day advance permit filings, mandatory public notification, and continued consultation on professional pyrotechnics. So this is where we have come from to create this bill. The 2022 consultations, we go back because we don't end, the world doesn't end when a government goes out of office, life continues, a nation continues. So we looked at that 2022 consultation, which was people coming forward to express their views. On January 7, 2022, the then Office of the AG and Minister of Legal Affairs, they released what I mentioned before, the Summary Offences Amendment Bill 22 for public comment. Submissions closed 26 January 2022. The consultations revealed a strong national consensus. Fireworks must be regulated or banned, and I mentioned the two models. Stakeholders supported a classification system based on explosive content, hazard level, and noise output, and recommended regulating or prohibiting the use of sky lanterns. Most participants supported a permit system with fixed fees, applications submitted at least 1 month in advance, and permits issued by district senior SOOPs and not the Commissioner of Police. So that's something that we have to look at. Some call for a full ban, restricted fireworks to trained professionals. Stakeholders, including TTPS, oppose exemptions for public holidays and New Year's night, warning that they would undermine regulation since usage peaks at these times. Alternatives suggested including retaining permits year-round, shortening the New Year's Eve window to 45 minutes, or restricting use to pre-approved locations. There is broad support for designated display areas such as parks and savannas, promotion of silent or low noise alternatives. The animal welfare groups argued high hazard fireworks should never be available to the public, and they called for fixed fees to prevent something called bribery. Fixed fees to prevent bribery. So people go in, they apply for things, and there's a transaction cost, some call it. They call it bribery. The AMA recommended legally defining environmentally sensitive areas and species, requiring at least 1 month's notice. The Point Fortin Borough Corporation describes sky lanterns as excessively dangerous. They call for regulation and neighbor notification within a half-mile radius. The TTPS supported regulating lanterns, strong classification rules, and the power to revoke permits. The Mayo Regional Corporation stepped into the consultations, and they recommended mandatory insurance to cover loss of life, injury, property damage, and so on. Even the industry supported reform. One of the suppliers of fireworks, Fire One Fireworks Limited, they warned that weak regulation or a ban would drive consumers to illegal imports or homemade devices, worsening the situation within 1 to 2 years. And ARIMA stepped into the game, Honorable Opposition Leader. The ARIMA Borough Corporation questioned issuing permits to individuals and recommending restricting approvals to event promoters for controlled displays. We did not take that recommendation, regrettably, because that will be put into the hands of the promoters, rather, the power in the hands of promoters who have self-seeking interests, instead of in the hands of people, the ordinary people of Trinidad and Tobago. So we move along. This is some of the history as we go on. And the people's complaints. Yes. Beyond expert analysis, the public record speaks with one voice. For years, letters have filled our newspapers. Doctors have warned, animal groups pleaded. Nothing changed under the former regime. Throughout October 2025, the Express and Newsday repeatedly published calls for strict regulation or a full ban. Express October 10, ban all fireworks or regulate them properly. We need a total fireworks ban. Express 28 October 2025. Ban fireworks once and for all. Newsday, October 31. End this fireworks assault on peace, sanity. Newsday, 23rd October 2025. Time to ban fireworks for good. 23rd October 25, Newsday. Fireworks are of no value. 28 October 25, Newsday. Restore quiet to TNT, 25th October, Newsday, 2025. Other letter writers compared fireworks to cigarettes and alcohol, condemning bamboo bursting, demanded enforcement, silent alternatives, or total prohibition. Many columnists and editorials added moral and legal urgency. Across every perspective, the conclusion was clear. Celebration had become fair, anxiety and harm. Thousands break fireworks law. January 3rd, 2025, published in the news, 1,000 break fireworks law. Widespread anger that sections 99 and 100 of the Summary Offences Act exist, but they are not being enforced. So there's an enforcement serious issue. When celebrations become tragedy, October 25, 25, the Express reported, fireworks terrorized baby who died hours later, documented the death of 3-day-old infant Kemani Gordon. Days later, neurologist Dr. Azad Isaac warned of serious health risks to infants and vulnerable persons. Animals, homes, and infrastructure. January 2025, so there's been a barrage of these complaints on the Speaker seeking relief. In the past, but in this last 6, 7, 8 months, There's been a barrage of pleadings, if I may call it that, for us to deal with this issue once and for all. January 3, 25, Newsday reported TTSPCA officials in tears rescued dog Jeremie does. December 24, Newsday, TNTech urges caution with fireworks. The history is long and devastating. 2006, multiple burns at a concert. A 15-year-old lost a finger. 2008, choir members burned at a public event. 2015, infant severely injured. 54-year-old lost 3 fingers. 2018, multiple hospitalization, including burns, lost fingertips, air trauma. 2022, a Port of Spain fire displaced 25 people, causing power outages. These are not isolated incidents. They represent homes destroyed, limbs lost, and many others harmed, animals killed, communities traumatized. So no country which values its people will leave them to suffer like that. Today, after years of silence and inaction, my government is enabling the Parliament to respond finally. EMA data, industry response, a clear timeline. The EMA is guiding us along, and I could go through those articles, which I'll leave for the moment. My position has been very clear, and our position on this side has been very clear. My stance against noise pollution is part of a long documented and consistent record, which began whilst the former PNM administration ignored the public's pleadings. On 31 January 2023, 31st July 2023, as opposition leader, I condemn noise pollution from bars, clubs, fetes as an intolerable scourge on the mental health of citizens. I expose what I described as systemic corruption in the licensing system, including ignored complaints, bribery, exclusion of residents from hearings, false supporting statements, intimidation of prosecutors and police officers, owning bars while evading enforcement. I call for urgent reform, citizen legal representation, accountability through the Commissioner of Police and the Police Complaints Authority and the Professional Standards Bureau. Mr. Speaker, on October 25th, 2023, I further warned against mischaracterizing noise-relaxed disputes as religious hate. There was a time when there seemed to have been a plethora of things talking about religious hate, when mosques and temples and churches were being damaged and vandalized. I reminded our country that we have always been a society where temples, mosques, and churches coexist peacefully. Further, I urge unity, responsible enforcement, and rejection of divisive narratives. Continuing on April 9th of this year, ahead of the SCA exams, I call for noise-free zones around schools. In fact, we went so far as to pause UNC campaigning near exam centers. They continue. We pause our campaigning for our children to have a better chance of succeeding. Across these years in opposition, my principles and those of us on this side have always been very clear. Noise pollution harms health, learning, and community peace. Noise pollution enforcement is broken and corrupted. Citizens deserve protection, rights, and representation. Children and vulnerable groups require safe, quiet environments. As opposition leader, I made 3 commitments in this regard. Of course, I've made many others, but in this regard, at least 3 commitments. 1, to reform licensing so citizens, not corrupt intermediaries, should have power. 2, to protect community schools and sensitive spaces. And 3, to hold polluters and enabling officials accountable. Mr. Speaker, the policy as contained in this bill before the House is not new. It's the fulfillment of those commitments that we made, whilst the former government refused to do its duty. Today we do what they never did. We act in the interest of all the people of Trinidad and Tobago. Mr. Speaker, I could go further, but I think my time is, I have 3 minutes. With your leave, Mr. Speaker, I thank you very much. I repeat that this bill carries more than clauses. This bill is grounded in humanity, dignity, and justice. This bill carries the voices and yearnings of the people. For nearly 2 decades, they pleaded, please listen to us. Today, we have listened. Today, we are acting. I say again, promises made, promises kept. I thank you very much, Mr. Speaker.
Honorable Attorney General.
Mr. Speaker, what is left for me to do? Very little. My colleagues are begging me to say, as the member for Arima has done, those words, which I shall not repeat. But I'd just like to make 1 or 2 quick points. I know we are going into committee. The member for Port of Spain South, I think, asked us to consider deleting clause 6. We will have a problem with that. There's a case, Taylor and Chief Constable of Cheshire, which says that the admissibility of video recordings is a matter of weight, not admissibility. So you don't strike it out straight away. So I suspect we will not agree to that. The Prime Minister said, the Honorable Prime Minister said that we can discuss in committee stage the other questions. Although I'd just like to point out that it is under this law, it is the police commissioner who authorizes and fire, EMA, municipal corporations, civil aviation. All that is required is that you do a notification. With those words, Mr. Speaker, I beg to.
Honourable members, the question is that a bill entitled An Act to Amend the Summary Offences Act, Chapter 1102, and for other related matters be now read a second time. Those in favour say aye. Aye. Those against say no. The ayes have it.
A bill entitled An Act to Amend the Summary Offences Act, Chapter 1102, and for other related matters.
Honourable Attorney General.
Mr. Speaker, in accordance with Standing Order 68-1, I beg to move that the Summary Offences Amendment Bill 2025 be committed to the Committee of the Whole to be considered clause by clause.
Honourable members, the question is that the Summary Offences Amendment Bill 2025 be committed to the Committee of the Whole to be considered clause by clause. Those in favour say aye. Aye. Those against say no. The ayes have it. This House shall now go into the Committee of the Whole to consider the bill clause by clause.
Clauses 1 to 4.
The question is that clauses 1 to 4 stand part of the bill. The question is that clauses 1 to 4 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clauses 1 to 4 now stand part of the bill.
Clause 5.
Sorry, Mr. Chairman. Okay, I can talk now, right?
The question is that clause 5 now stand part of the bill.
Mr. Chairman?
Yes?
Respectfully, we have circulated some proposed amendments, and particularly as it relates to Section 99, we are proposing an amendment for an inclusion of a 99 subsection 3 to read, an online permit application system may be established under this section, which the rationale for that is it will give persons an opportunity not to bombard the office of the Commissioner of Police, but to do an application online for the permit. And that's the rationale for our respectful submission to the Honorable Attorney General in this regard. So we add, after 1 and 2, we add that as a clause 3. That's our proposal.
Honorable Attorney General.
Chair, there's no disagreement on our part with that proposal, and the other proposal with respect to clause 5, I'm not sure whether you wish to read that out separately.
Can we do it separately? Because I want to make a comment.
Okay.
Speak to them.
Can we do it separately? Because I want to comment on it.
Yes, I suppose so. I suppose the deliberation of the committee thus far, Attorney General, you propose to accept the suggestion that there be a new subsection 3 to permit an online permit application system. Right.
Add to that. A little bit of my contribution a short while ago talking about the technology and blah, blah, blah. So we are totally open to accepting it and, of course, in due course, to bringing it online. So thank you for the suggestion.
Thank you, Honorable Prime Minister.
The second.
You all don't know decorum and respect?
All right, let's let the spirit of magnanimity continue. Can we please, let's prolong the spirit of magnanimity. All right. Can I, Participant South, is it your intention to speak to the second proposed amendment to 1011?
Yes. Mr. Chairman, we propose to insert the words Fire Service, Environmental Management Authority at 101, subsection 1, Civil Aviation Authority and Municipal Corporation. Mr. Chairman, for pure transparency, in the report of the Law Commission, the EMA had suggested that they don't have the remit to monitor fireworks. We are of a different opinion. We think that part of their remit under the environment must include that, but I must put that and lay before the House. I can't make the suggestion without telling the House that if they look at the Law Commission report and the EMA's position, I think is at page 58, you will see that they have made that as a submission, but we are not bound by their submission because I think that they are fettering their hands, and we would like it to be included. Mr. Chairman, may you allow me, whilst the Honourable Member for Port of Spain, North, St. Anne's East, confer with the leader, please?
Thank you very much. Mr. Chair, just to add the point that the Attorney General had made in his winding up on this. It is a mere notification. So the EMA having power or remit is of no moment whatsoever. It is just that they are notified that a permit has been granted to whoever it is, X, Y, and Z, that on this day, these are the fireworks that they will be discharging, the type of fireworks, the amount, etc. So it's a pure notification. It's then up to them as to whether they want to deploy their own resources or not. But there's no obligation on them whatsoever.
Having spoken to the leader and the whip, we would want that the EMA to be included, please. And I agree.
Honorable Attorney General.
Again, we do not have a difficulty. In principle, we'd like to suggest that the words "the relevant municipal corporation" are changed to "municipal corporation responsible for the municipality in which the fireworks are to be discharged."
I think that satisfies.
Yes, it's actually very specific.
Principle of legal certainty more than anything else. So can I now, there being some agreement on that, can I now suggest we move forward to the proposed amendment to section 101E4, and I think there was some suggestion on the floor of the debate about that.
In the debate, the Honourable Member Superior did indicate that there was support for the augmenting of the 14 days to the 28 days, and we would ask that this be transmitted to the committee stage and accepted, please, Chairman.
Honourable Attorney General.
We agree with that, Chairman.
So the question now is that clause 5, Honourable Attorney General, I'm being asked if you could be so gracious enough and patient enough to repeat the proposed amendment with regard to the municipal corporation. My recollection is that the municipal corporation in the municipality in which the fireworks are proposed to be discharged. Is my recollection good enough?
Chair, if you'd permit me to
Sure.
just, municipal corporation responsible for the municipality in which the fireworks are to be discharged.
There being agreement, I propose to put the question. The question is that clause 5 be amended in the terms as agreed, as circulated and agreed. And further amended.
Proposed subsection 101.
Subsection 101(1) by deleting the words "the relevant municipal corporation," by deleting the words "the relevant," keeping the word deleting the word "relevant," and inserting after the word corporation, responsible for the municipality in which the fireworks are to be discharged. In section 101E4,
That was uncirculated. That would count as circulated.
okay.
Is that clause 5 be amended? Those in favor, let us vote.
Question is that clause 5 be amended. Those in favor say aye. Those against say no. The ayes have it. Right, so that's it. The question is that clause 5 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 5 as amended now stands part of the bill. Clause 6. Port of Spain North.
Thank you very much, Chair. We have heard the contributions of both the member for Siparia, the Honourable Prime Minister, as well as the Honourable Attorney General on this, and in particular the case that the Honourable Attorney General just referred to in his closing up. Our concern with respect to this, and in particular it is B2, a video recorded by means of a mobile phone, tablet, iPad, or other similar smart devices shall be admissible as evidence, is that it is too far-reaching. We understand what is trying to be achieved because we understand in particular with the fireworks, we've all seen it, videos on social media that had to have been recorded by someone's device. The difficulty becomes in the application in law because as both the Honourable Prime Minister and the Attorney General would know, you would have to lay an evidential foundation. So for example, with the use of CCTV camera that is now admissible, you would have to lead a foundation that says, these are the cameras, they're pointing in a northerly direction, the recording works, the DVR has been tested, it works, etc. There's been no difficulty with it, etc. Something as simple as someone with their own camera, they have to lay the evidence saying, I pointed my camera at the member for Faizabad in a northerly direction, my camera was working, I snapped it, I looked at a photograph, I looked at what was shown on my camera, and it is an accurate reflection of what I saw with my own eyes. The difficulty with this, especially in this day and age of technology, as most of us in this house would know, is the mischief that people can make very easily with their same smart devices, video recordings of persons. They can impose a person's face onto the video recording, and these then fall into this category. And there is no way, for example, in the instances that I've described where you see people setting off fireworks, for example, in East Port of Spain and other areas in my constituency as well, that you can then find or locate who was the maker of the video to go through that evidential burden and the foundation. So I heard what the Attorney General said, and that is not as to admissibility, but it is as to weight. But this is far-reaching, and if we go this far, it is our concern is going to tie up court time with the challenges, and it will do more harm than good. And we are very, very concerned about the use of devices, especially in this day and age, and the mischief as we've all seen. So a few months ago, there were videos, for example, of the member for Siparia and myself sparring and these types of things, which obviously isn't true, and this type of thing, right? So these are some of the examples of what can take place. And this is we're just saying at this stage, we don't think we should go this far, and we should just delete it and allow the normal law to take its place.
Honourable Prime Minister.
I've listened to your concerns, sir, but I think in a sense you have given us an answer to this, why we should not delete it. You have to lay the foundation, so it can't be, as you know, in evidence. You gave all the examples that you have to, who did it, when they did it, was the breeze blowing left, was it blowing right, was it upwards, whatever. So that foundation must be laid. I think to have a middle ground, we can change the word shall be into may be.
I was now going to suggest that, Honourable Prime Minister, because it says shall be admissible, which then seems to affect that need for the foundation. Maybe we can go with may be admissible in accordance with the...
Can I,
Sure.
can I venture without being accused?
I think you should be very careful, Mr. Speaker. The AG has his people there. I know you have the experience
Mr. Speaker,
of
maybe
evidence.
my contribution may...
I think Choko Sangri wanted to, being a very experienced criminal lawyer.
Mr. Speaker, the court always has a discretion to deal with matters of admissibility, and in fact, the case of Taylor and Chief Constable of Cheshire deals specifically and exactly on all fours with what the member for the Spain North suggested. In that case, it was not the maker of the video recording who had given evidence as to what was the contents of the video. So, in fact, the video itself was deleted after someone had seen it. And a reference was made to many cases where it is a matter of real evidence, so the court would look at it and in any event take into account such factors as we are referring to and decide whether it should attach what weight, if any, to the video that is admitted into evidence. So it doesn't preclude admissibility.
For the Spain South.
Mr. Chairman, we are grateful to the suggestion from the Honourable Member for Siparia. Will assuage some of our concerns because it will deal with things such as chain of custody and prerequisite or preconditions for admissibility. And we are not totally happy, but we are relatively sanguine in that position, so we will not belabor the point.
Chairman, just at the risk of belaboring the point, the section as it is drafted just says, shall be admissible. Okay, it's up for the court to decide whether or not it is to be admitted. The fact that it is admissible does not mean, I think that is the point that my friend was trying to make.
I think
that it is going to be.
Love to give us.
I would, but I think I'm being I think I'm being intellectually hogtied by some members, but that's just a joke.
Chair, we're okay with the amendment.
Yes.
My view, it doesn't take the matter of one way or the other. So shall we say the question is that clause 6 be amended by in 6B2 by deleting the word shall and substituting it with the word may. Those in favor say aye. Aye. Those against say no. The ayes have it. Honorable members, the question is that clause 6 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 6 as amended now stands part of the bill. Honorable members, the question is that the bill as amended be now reported to the House. Those in favor say aye. Aye. Those against say no. The ayes have it. The bill as amended will now be reported to the House. General.
Mr. Speaker, I wish to report that the Summary Offences Amendment Bill 2025 was considered in the Committee of the Whole and approved with amendments. I now beg to move that the House agree with the committee's report.
Honourable members, the question is that this House agree with the committee's report on the Summary Offences Amendment Bill 2025. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable Attorney General.
Mr. Speaker, I beg to move that a bill entitled An Act to Amend the Summary Offences Act, Chapter 1102, and for other related matters, be now read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Amend the Summary Offences Act, Chapter 1102, and for other related matters, be now read a third time and passed. Those in favour say aye. Aye. Those against say no. The ayes, division having been called for, let's proceed to take the division.
Mr. Padara? Yes. Mrs. Persad-Bissessar?
Yes.
Mr. Tanku?
Yes.
Ms. John?
Yes.
Dr. Munilal?
Yes.
Mr. Lee?
Yes.
Mr. Hussain?
Yes.
Ms. Amin?
Yes.
Mr. Alexander?
Yes.
Mr. Maraj?
Yes.
Ms. Mohit?
Yes.
Mr. Sturge?
Yes.
Dr. Bodo?
Yes.
Dr. Dowla?
Yes.
Dr. Ali?
Yes.
Mr. Morris?
Yes.
Ms. Benjamin?
Yes.
Mr. Sobers?
Yes.
Mr. Watts?
Yes.
Dr. Sicharan?
Yes.
Mr. Kisa?
Yes.
Mr. Elder?
Yes.
Mrs. Sam?
Yes.
Mr. Narayan Singh?
Yes.
Dr. Rupnarayan?
Yes.
Dr. Gosai?
Yes.
Mr. Thomas?
Yes.
Mr. Gonzalez?
Yes.
Mrs. Beckles Robinson?
Yes.
Dr. Gatsby Dolly?
Yes.
Mr. Young?
Yes.
Mr. Scotland?
Yes.
Yes, as amended.
Mr. De Nobriga?
Yes.
Mr. Manning?
Aye.
Mr. Marcel?
Yes.
Mr. Devines?
Yes.
Mr. Birchwood?
Yes.
Mr. Romaine?
Yes to PNM legislation.
Mr. Speaker, the result of the division is 38 members voted in favor, no one voted against, and there were no abstentions.
The results of the division are 38 members voted yes to the bill, 0 members voted against, and there were no abstentions.
A bill entitled An Act to Amend the Summary Offences Act, Chapter 1102, and for other related matters.
Huh?
Motions.
Minister of Finance.
Mr. Speaker, I rise to speak to the motion number 1, which is in the name of the Minister of Finance.
Yes. I'd like to move the following motion.
I'm sorry, he's tired. I do have a procedural note. I beg to move the following motion standing in the name of the Minister of Finance. Be it resolved that the Senate amendments to the Virtual Assets and Virtual Assets Service Providers Bill 2025, listed in the Appendix 1, be now considered.
Honourable members, the question is that the Senate amendments to the Virtual Assets and Virtual Assets Service Providers Bill 2025, listed in the Appendix 1, be now considered. All in favor, say aye. Aye. Any against? The ayes have it.
Clause 3, in subsection 1, delete the word emerging. Clause 5, delete where it occurs in the second instance. Clause 16, sub 3, A. Insert after the word sandbox participant the words "and with the permission of the sandbox participant." And B. Insert after subsection 3 the following new subsection. 4. Where permission is not granted by the sandbox participant to enter the business premises, under subsection 3, the Commission may apply to the High Court for a warrant to enter the business premises of the sandbox participant to conduct the powers set out in subsection 4A, B, and C. Clause 21(2), delete where it occurs in the second instance. Clause 28(a), in item proceeds of crime, in the second column, in paragraph D, delete subparagraphs 4 and 7. And B, renumber subparagraphs accordingly.
Attorney General.
Mr. Speaker, subsequent to the introduction of the bill in this House, a number of stakeholders approached the government with concerns that the bill would cause them to have to cease all operations. This government, through one of the working groups from the Ministry of Finance, had attempted to ascertain the level of involvement in the virtual asset and virtual assets provider sector without success. Having regard to the secretive nature of that sector generally, there seemed to be an unwillingness at that time to divulge the extent of their operations. On meeting with the sector on two occasions, on one occasion it was the Minister of Planning and Development, on the other occasion it was the Governor of the Central Bank and myself, together with the Minister and the technocrats. It was agreed Oh, I see. I'm told that there's a procedural bit which we've all missed. Well, certainly I have missed it. Mr. Speaker, I beg to move that this House agree with the Senate in the amendments to clauses 3, 5, 16(3), 21, 2, and 28 of the Virtual Assets and Virtual Assets Service Providers Bill 2025. That's it. Take it that all that I've said has fallen on fertile ground. May I continue, Mr. Speaker? So, Mr. Speaker, the bill had to be amended significantly to accommodate a feature known as a regulatory sandbox. Provisions had also to be included in the bill to provide a framework as to who could enter the sandbox, the approval to do so, and the removal in certain circumstances. That meant that voluminous amendments to the bill and the bill which had been laid was necessary. In the Senate, the existing clause 5 of the bill, which was required to be deleted, was unfortunately not deleted and resulted in there being 2 clause 5s in the bill. The second amendment involved a repetition of subclause 21(2), which was missed in the drafting of the amendments. The third amendment proposed by the government was in respect of clause 28, which contain the schedule with a consequential list of amendments. The amendments to the Financial Obligation Regulations of the Proceeds of Crime Act in the schedule contain amendments to regulations 33 and 34, and our technocrats indicated that those amendments were no longer required as the substance of the amendments were contained in new regulation 33A. There was, Mr. Speaker, one further amendment which the government took on the floor from opposition Senator Mr. Faris Al-Wari, who then proceeded to vote against the bill. But we took the amendment in good faith, and he proposed that consent should be provided for the entry into premises under Clause 16. The government took this amendment, made provisions for the obtaining of consent of the owner of premises before entry. Mr. Speaker, these amendments were approved by the Senate at committee stage of the debate on Wednesday, the 26th November 2025. Mr. Speaker, I beg to move that we are.
Honourable members, the question is that this House agree with the Senate in the amendments to clauses 3, 5, 16 subsection 3, 21 subsection 2, and 28 of the Virtual Assets and Virtual Assets Service Providers Bill. Diego Martin West.
Thank you very much, Mr. Speaker. I rise today to contribute and speak on the amendments to the Virtual Assets and Virtual Asset Service Providers Bill 2025, which has returned to this August House, having come through the Senate and further amendments being made. When this bill was first introduced and laid in the Parliament, we knew there were fundamental flaws, and we acknowledge that. And in the spirit of today, we are not here as opposition just to oppose. We are here to hold the government to account that we have good legislation that can stand the test of time. When this bill was introduced, we were bombarded with a 49-page document with amendments. I'm finishing my contribution, Prime Minister. Let me just get through it, and we'll get through it. All right? So we were able to look through these amendments because of the scrutiny of the Senate. We, as the opposition, we support these changes because, once again, we expressed our concerns over the hurried process and the injection of the last-minute amendments on the floor. We said what we had to say. And just to correct the AG, it's not necessarily that this industry is secretive, but when you're talking and you're trying to let your voice be heard, and someone is continuously ignoring you, they tend to feel like they can't speak to you anymore. And when you start to listen, it shows a change in approach, and a change in the way we can move forward as a country and look towards the future. The fact that the bill has strengthened and has been refined through the amendments in the Senate, it provides the necessary assurance, even in terms of Clause 16, where Senator Faris Al-Wari made a sterling contribution, and we see an amendment made here. Now, listen to this. To the members on the other side, we are prepared to support the passage of this legislation because we understand the necessity and benefit of global compliance. The most critical benefit of passing this bill is achieving full FATF compliance. This is not merely an administrative exercise. It's an economic imperative. So by formally regulating the virtual asset service providers, we are demonstrating to the international community that Trinidad and Tobago is serious about tackling money laundering and terrorism financing in the digital space. The benefits of this compliance is the preservation of our correspondent banking relationships. It means protecting our financial sector from being placed on international grey list or worse, blacklist. Mr. Speaker, this compliance is the foundation upon which our trade, foreign investment, and economic stability rest. We must remove
Mr.
any
Speaker,
doubt.
I know that we are still in the spirit, but 48.1, please. This is a very strict debate in terms of just dealing with these clauses. And thank you.
I think I was giving Diego Martin West a little... I know there's a lot of test cricket going on, and fast bowlers are ruling the route, but shorten the run-up. Take a page from Malcolm Marshall. Bowl off your short run-up and be just as lethal.
Yes. So, Mr. Speaker, with reference to the amendments, again, the regulatory sandbox and existing participants, it's something that we see here, and it is something that we support because we needed to give these professionals and not kill this industry. So we say thank you for that. Our concern, again, remains adequately staffing the Commission, which we look forward to seeing the government implement in some way, form, or fashion. This and these amendments are necessary for the digital financial future of our country. We support the changes brought in from the Senate. We recognize the profound benefit of securing our international financial standing through this critical legislation. Our support is contingent upon the government's commitment to immediate and adequate resourcing of the TTSEC to make this law effective. With those words, Mr. Speaker, we support the amendments and the passage of this bill, and I thank you for contributing. Thank you.
Honorable Attorney General.
Mr. Speaker, it is 6:41. I beg to move.
Honorable members, the question is that this House agree with the Senate in the amendment to clauses 3, 5, 16, subclause 3, 21, subclause 2, and 28 of the Virtual Assets and Virtual Assets Service Providers Bill 2025. All in favor, say aye. Aye. Any against? The ayes have it.
Thank you most kindly, Mr. Speaker. Mr. Speaker, I beg to move that this House do now adjourn to a date to be fixed.
Honorable members, before I put the question, some matters, but one matter qualifies to be raised on the motion for the adjournment. I will now call on the member for a remark.
Thank you very much, Mr. Speaker, for affording me this opportunity to raise this motion on the adjournment. And in the spirit of goodwill that has been transpiring for the evening, I propose not to be very long, but it's an important matter, and I thank my colleagues for all giving me the opportunity to raise this matter. Mr. Speaker, the matter has to do with the need for the Ministry of Health to reinstate all required services at the Blanchisseries and Brasso-Seco Health facilities. And in so doing, Mr. Speaker, I would also like to ask the Honourable Minister of Health to extend this goodwill to the residents of the North Coast by reinstating the required services at Blanchisseuse and Brasso-Seco Health Facility. So, Mr. Speaker, just to indicate that my concern is raised because those areas of Lafayette, Blanchisseuse, Monlacroix, Paria, and Brasso-Seco, originally the facilities there offered health services during the period 8 to 8 and on weekends. And from the month of October, those services, those health services no longer exist for the people of those communities from which I made mention. It was just about 2 weeks ago when I visited my constituency office. Several of the residents raised that concern that essential medical services have been restricted, reduced, and withdrawn. Mr. Speaker, I just want to use the opportunity just to share some quick data that I think is important, especially because of the removal of the services on a weekend. I just want to quickly indicate, just using 4 examples. In 2020, Anthony B. Parks drowned on a Saturday. September 9, 2024, another drowning on a Sunday. Anthony Charles, February 2022, Kareem Grant of Samoa again on a Sunday. And December 2023, I want to make reference to a landslide that took place on a Saturday. Now, why am I saying that, Mr. Speaker? I'm saying that because I think it is true to say that in those communities, a lot of people go to Blanchisseuse, go to Lafayette, go to Las Cuevas, mainly on a weekend. And that is the time we have seen, whether it be accidents, whether it be landslides. And it's not that it doesn't occur during the week, but more so that people go during that period to enjoy themselves. And very often accidents occur. It is an area where you have a lot of hiking, and as a result of that, people will go to the health center on a weekend or sometimes late at night. And we have seen just recently where someone was lost in the forest, and the Hunters Association found that person. Another person was lost in Tree Pools, and that is in the Avocat area, again in the North Coast. So I'm saying to the Honorable Minister of Health that I would like you to give serious consideration to restoring those services that existed in those communities, because we understand what can happen. And it's not, very often it's easier sometimes to move from Las Cuevas to go to Blanchisseuse as distinct from going from Las Cuevas to Port of Spain. Mr. Speaker, why is it also so important? It's important because in those communities you don't have transportation, particularly on a Saturday and a Sunday, and sometimes more so during the night. So there's also the challenges as it relates to the ambulance services, which has also, I am informed, reliably informed, no longer exist on a weekend. So the services have been reduced from 8 to 4, and you also have the situation where it's no longer exists on a weekend. Mr. Speaker, I also want to make reference to the Brasso-Seco Health Facility, and that facility previously operated just 2 days a week. The Tuesdays dedicated to the antenatal clinic and Thursdays dedicated to the doctors. And Mr. Speaker, what has happened now is that the facilities, they're only offering services from 10 a.m. But the doctor arrives around 10 a.m. and normally ends at 1 p.m. So I'm asking the Minister of Health to seriously consider the persons that live in those areas because of the challenges that they face. I also want to ask the Honorable Minister of Health, in considering my request, to also look at the disaster response site, NCD Prevention and Retreat Center, which was built at the cost of some $2.9 million. Honourable Minister of Health, that facility has not been opened. And again, why was that facility built? That facility was built mainly to deal with the issue of disaster responses. And we're talking about several communities in the North Coast. And I would ask him to consider that facility being open. I think it is fair to say that a number of members of Parliament here understand the challenges when you have rural communities. And I therefore, Honourable Minister, I am pretty certain that hearing my request that you will give, I'm asking you please to give favourable consideration on behalf of the residents of the North Coast. I thank you very much.
Honourable Minister of Health.
Thank you. Thank you, Mr. Speaker. I want to thank the member for raising a very important issue. Of course, this government remains focused on providing total and proper health care to all citizens of Trinidad and Tobago based on needs, regardless of their geographical location. In our previous incarnation as a government, we ourselves would have extended open hours at Cedrus and other remote areas, including Toko and so on. Just to address quickly, member, I want to give the assurance that we will consider your request, but just to put on the record, just for the population, that the Blanchisseuse Health Centre remains open 8 to 4. I believe what you're alluding to is the extended hours that happened over the weekends, a process which would have started in 2019. What has happened is that if we look at the figures for 2025, it has come to the attention of the NCRHA, which oversees that facility, that on average there are only 2 patients that attend that facility. These are the figures I have here. In the interest of time, I may not be able to read all of those figures. And that facility would have cost some $500,000 a year to maintain. So I think it was a cost-benefit analysis, but nevertheless, that consideration will be given. Just to note that even though that facility would have stopped those extended services at the end of October, some of those funds would have been redirected to the opening of the St. Joseph Health Centre on a 24-hour basis, at which will enhance the facilities at the Eric Williams Medical Sciences Complex. So it was really an exchange here. With regards to the Blanchisseuse NCD and Disaster Response Centre project, Member Farima, my information is that this facility was very ceremoniously commissioned in February of 2025 under the watch of your government at a cost of $2,912,596. However, Member Farima, on assuming office on May 1st, 2025, we in the Ministry of Health could find no published operational plan to commission the NCD services or disaster response center. Member, we are unaware of the scope of these facilities, as it was originally intended, I believe, as a staff quarter to serve the Blanchisseuse Health Centre. Member, there have been no recorded events, activities, or any such use for the purpose for the unit, and no patients have been recorded at the centre since the very ceremonious opening. And to our knowledge, no patients or members of the community have benefited. But nevertheless, if it is a structure there that needs to be operationalized, our philosophy, of course, is to provide care for the citizens of Trinidad and Tobago. And just 2 days ago, you would have noted, member, that the Honourable Prime Minister would have opened a facility in Couva, the Couva Children's Hospital, that was abandoned by your government for the past 10 years. And member, I want to give you the assurance that we will give consideration to what you have asked for, and we will continue to serve all of the citizens of Trinidad and Tobago on a fair and equitable basis, based on need and regardless of geographical location. Mr. President, I thank you. Mr. Speaker, sorry, thank you.
Members, before I put the question on for the adjournment, as you are all aware, we are in the Christmas season, and I should like very much to call upon members to say a few words on this joyous season of Christmas. I'm advised that the member for St. Anne's East will speak on behalf of the opposition, and I now call upon her.
Thank you kindly, Mr. Speaker. Mr. Speaker, on behalf of the opposition leader of the People's National Movement, the member for Rima, the Honourable Penelope Beckles-Robinson, and all members of the opposition bench, I rise to bring Christmas greetings with a heart full of gratitude, deep reflection, and not a little solemnity. Christmas is a sacred and deeply spiritual season for the Christian community, one which commemorates God's gift to humanity, Jesus Christ, the gift that keeps on giving. The real meaning of Christmas is much deeper than gift giving, but the festivity and celebrations are meant to reflect the glorious heavenly chorus which heralded the birth of Jesus. Christmas speaks of the miracle of hope. Jesus, the gift of life, choosing to be born in a humble place on this earth he created. Christmas reminds us that darkness, however impenetrable it seems, will always be conquered by light, that fear is no match for the love of God, and that peace, which passeth all understanding, thrives even in uncertain times. Christmas calls us to live peaceably with all men, to forgive our debtors, even as God forgives our debt, in the order of 70 times 7, to pray without ceasing, and to bless others with a spirit of generosity and genuine care for their well-being, not simply to be seen by men. While festive for some, this Christmas season of 2025 will be difficult for many, and we must pause to remember the families across Trinidad and Tobago who are facing uncertainty due to job loss and income reduction. There are many carrying burdens which may remain unseen, should we not look with eyes that truly care. This Christmas, let us remember those who may have lost hope, the parent desperate to provide for their children, the retrenched worker seeking out opportunities to earn, and every household feeling the weight of hardship. Let us all pledge to do whatever we can to give the gift of hope this Christmas. Today, the PNM says that those who feel hopeless, tough times will not last forever. As we reflect on the birth of Christ, we are reminded that hope was born in humble circumstances. And from that humility came a message that still calls us to love, to serve, and to give. Let this season inspire us to be more compassionate leaders and more generous citizens. Let us open our hearts and hands to those in need. Generosity is not measured only by what we give, but by our kindness, understanding, and willingness to lift each other up. On behalf of the opposition bench, once again, I extend warm Christmas wishes to this honourable House and to all the people of Trinidad and Tobago. The little gift you send on Christmas Day will not bring back the friend you turned away. So may I suggest the secret of Christmas is not the things you do at Christmas time, but the Christmas things you do all year through. May God bless us, Merry Christmas, and a happy and prosperous 2026.
Honourable Prime Minister.
Thank you very much, Honourable Speaker. I endorse the words of the member, and thank the member for her greetings today, the member for St. Anne's East. Thank you, member. And I join in bringing greetings on behalf of the members on this side of the House. And today represents our final day, all things being equal, our final day in having a sitting in this House before the end of the calendar year, end of December. And so we have had 7 months leading up to where we are today, full of debate, some banter, and some not banter. We've had heated debates in this House over the last several months since this session, this is what the session of this Parliament, when we began post-April 2025. So some very serious legislative responsibilities, healthy debate, dedicated service. So I take this opportunity, Honourable Speaker, to extend warm Christmas greetings to all members of this House, to extend greetings to the staff and members, the officers here in this Parliament who sustain our operations, and of course to every citizen of our beloved nation. In some respects, this year, this session of the Parliament was, can I say no to people? This, yeah, marked by, to some extent, renewal. And this is the first session of the 13th Parliament that we've been engaged in. And since we got the mandate, overwhelming mandate in April 2025, we have worked very steadily to strengthen our economy, to restore fairness to governance, to support workers and families, to build a safer, more compassionate, and opportunity-rich nation. And we've only just begun, Mr. Speaker. We've only just begun. Only Sunday, Mr. Speaker, we were able to rededicate the Couva Children's Hospital. Which was, in this Christmas season, a gift to our nation's children. We were able in this session, Mr. Speaker, Couva Children's Hospital that I mentioned, we were able to keep the promise that we made to the PSA to award them 10%. We kept our commitments to TNTech workers, to NIB workers. There are so many more which we'll talk about on another occasion, but let me just remind all of us, in addition to these matters, the very bill we are here today, earlier today, to debate is in fact another deliverable as a promise made and a promise kept. And let's not forget the stand your ground law tour. That's another one that we were able to deliver in the Parliament. So legislatively, Mr. Speaker, in this House, we have kept many of the promises we made. Not much breathing time, but we intend, as I say, to continue in that vein. And we will reveal to this Honourable Chamber our legislative agenda. I had planned to do it, but it keeps growing every day. So to the members of the other side, in the first sitting of the Parliament in the new year, we will share with you our proposed legislative agenda. So, as we enter into this holy season, we are reminded of the true reason we celebrate the birth of our Savior, the Lord Jesus Christ. His coming into the world represents love, mercy, and redemption. The Gospel of Luke gives us these words, and I quote, "For unto you is born this day in the city of David a Savior, which is Christ the Lord." Christmas calls us to reflection and renewal. It calls us to lead and to live with compassion, patience, and goodwill. Charles Dickens, Mr. Speaker, I know you may be well familiar because you're an avid reader of literature. He told us in his timeless novel, A Christmas Carol, he wrote, I will honor Christmas in my heart and try to keep it all the year. And I think the message from the member of St. Nancy's echoed those sentiments, that it should not be only at Christmas time, but for the entire year. That sentiment should guide us in public life. Service not only as duty, but as kindness in action. To every member of this House on both sides, we offer our sincere best wishes. May you spend this season in peace, with family, with faith and rest. And when we return in the new year, may we do so with renewed commitment to the people who put us here and sent us here, with humility, clarity of purpose, and a deep resolve to serve our constituents and our nation with integrity, wisdom, and compassion. Mr. Speaker, I extend special appreciation to you, Honourable Speaker, for guiding this House with order, dignity, and balance. Now, Mr. Speaker, I'm not a great cricketer, but I do appreciate when you share with us the run-up and the not the run-up and all the other cricketing terms. If I say so, if you permit me, sir, I think we have learned a lot under your guidance in this chamber. And we will continue to push the boundaries, to go beyond the boundaries in our debates and in our behavior in this Parliament. To the clerk, the parliamentary officers, protective services, and every member of staff who ensures the smooth functioning of this institution, we express heartfelt thanks. I know sometimes the staff here go beyond the call of duty, because sometimes we begin early, and sometimes we are here early, which means sometimes in the wee hours of the morning. So thank you for your dedication. Please share it with the other members of the staff, and thank you for your service to the people of Trinidad and Tobago. Your service sustains our democracy and the democratic life of our nation. In conclusion, as we look to the coming year, let us do so with hope. May 2026 be a year of continued progress, strengthened unity, and deeper achievement for the betterment of all citizens. May this Christmas be safe, blessed, holy, and joyful for every household. May the message of this Christmas guide us beyond the season and throughout the year ahead. May God bless you, and may God bless our nation. Merry Christmas, and I thank you very much.
I too should like to join members with some words of my own in this Christmas season. It is an honor to extend heartfelt greetings to the entire Parliament and the entire country on this holy and jubilant occasion of Christmas, a festival observed the world over by Christians and non-Christians alike, for its warmth, laughter, charity, generosity, unity and togetherness, and magnanimity of spirit. The word Christmas has its genesis in an old English phrase meaning Christ's Mass, and celebrates the birth of the baby Jesus Christ. For many Christians, the Christmas season begins on the first Sunday of Advent and continues until the Epiphany, January 6th, marking a season of prayerful anticipation and a joyous celebration. The historical and theological validity of the date for Christians is found in a calculation that predates this Roman solar festival. As early as 204 BCE, and codified by the time of Sextus Julius Africanus around 2021 CE, early church writers established the date by linking the date of Christ's incarnation to his death. The Calculus Civilis placed the Annunciation on March 25th. Counting 9 months forward yields the Nativity on December 25th. The early establishment of this Christian date by figures like Hippolytus of Rome in or around 235 CE demonstrates that the Christian celebration was rarely chosen for its profound theological reasons. In Trinidad and Tobago, our celebration is rich, unique, and sometimes a peculiar cultural expression. We celebrate Christmas with the infectious rhythm of parang music, warm visits to family and friends, the exchange of gifts, and the imbibing of good food, and the endorphin master is not here, and drink. Our tables overflow with local delicacies such as pastels, baked turkey, ham, garlic pork, sorrel, ginger beer, and the beloved poncha creme. It is truly a period of good cheer, well wishes, camaraderie, and fun. But Honorable Prime Minister, to borrow from you and your love of Dickens, I too, in getting here, also have a quote from Dickens. Because at Christmas, for some, it reminds us of Dickens's phrase, opening lines, in A Tale of Two Cities. It was the best of times, it was the worst of times. It is important to note that whilst many of us may be having what we call a grand time, there are others who may not be as fortunate, or may have lost loved ones over the course of the year, and may not be in the ideal festive mood. Let us keep them in our thoughts and prayers, and let us be kind, generous, and charitable to each other. Jesus Christ is considered the light of the world. Let this light overcome every darkness and despair. Let it shine resplendently over our beloved nation of Trinidad and Tobago. As a people, let us use this time to not only enjoy ourselves, but do some deep reflection and introspection on who we are, where we want to go individually and collectively as a nation. The important point to be made is that the baby Jesus was born in a manger, a place of discomfort, hardship, and humility. But the place of birth and the circumstances of birth do not dictate your final journey. So as we celebrate this Christmas, let us move forward humility, kindness, compassion, grace, and generosity. Let us strive to rekindle that light within us and uphold love, faith, and hope. Let us continue to serve with grace and wisdom. And remember, the edifices and the buildings and the structures we construct during our lifetime will all crumble, but the ideas and the philosophy which we propagate will live on forever. On behalf of the Parliament of the Republic of Trinidad and Tobago, I extend warmest greetings on the occasion of Christmas to the Christian community and indeed our entire nation as Christmas is woven into this social and cultural tapestry of this country. A very happy and Merry Christmas to one and all. So now, honorable members, all that is left for me to do is to ask the question that this House do now stand adjourned to a date to be fixed. All in favor, say aye. Aye. Any against? Right. This House now stands adjourned to a date to be fixed. Thank you very much and good night.